Given the waivers, the court will consent to hear the matters. Court calls the case People of the State of Michigan versus Derek Jones.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Jones. Mr. Jones, would you please state your name for the record?
Derek Jones.
Good morning, Honorable people.
What are we doing?
Your Honor, we are asking for a preliminary examination. Mr. Jones wishes to appear by Zoom, so Mr. Cook said that he would be able to do a writ within 2 weeks as opposed to the normal time. And we are asking that
A preliminary examination by what kind of case is it? Because the court has to make a determination as to whether or not it would be appropriate for a Zoom.
Your Honor, may we approach briefly?
May. For exams. Discovery is complete.
Yes, Your Honor.
People would have their witnesses available the 21st.
Do our best, Your Honor.
Preliminary examination. I will indicate that the defendant may appear via Zoom.
Thank you, Your Honor.
Preliminary examination will be set for April 21st, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you. Court calls case People versus Evan Sherbert.
Your Honor, Raymond Cook. Good morning, Your Honor. Assistant Public Defender Davy Leva on behalf of Mr. Sherbert.
Sherbert? Okay, thank you.
And I'm requesting adjournment so I can review an offer that I received.
Probable cause conference will be adjourned to April 23rd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls case People versus Cecilia Cotton.
Overwater Assistant Prosecuting Attorney for the People.
And Assistant Public Defender Nick Bukovich for Mr. Cotton.
Sir, state your name.
Cecilia Cotton.
Thank you.
At this time, Your Honor, we are requesting an adjournment to further negotiations.
You want 2 or 3 weeks?
Whatever the court deems appropriate. My client is in custody till December.
Yeah, I see that. So, probable cause conference, April 30th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Larry Evans.
And Overwater Assistant People.
Good morning, Your Honor. Edward Dukes on behalf of Larry Evans.
Your name, sir?
Larry Evans.
Thank you.
Your Honor, we're asking for an exam.
Sir?
We're asking for a preliminary exam.
Discovery is complete.
To our knowledge.
People have their witnesses available the 23rd. Preliminary examination in person, April 23rd, 2026. AM Bond or before Judge Washington. Bond continue.
Thank you, Your Honor.
Court calls case of the People versus Travis May.
Overwater Prosecuting.
Edward Dukes on behalf of Travis May.
May, can you unmute and state your name, please?
Yes, my name is Travis May.
All right.
Thank you, Your Honor. There is some negotiation that's underway. I'd be asking for an adjournment.
Probable cause conference will be adjourned April 30th, 2026, 9 a.m. Bond.
Thank you, Your Honor.
Thank you, Mr. May.
Thank you.
Court calls the cases of the people versus Corey Jones, 2 cases.
People.
Edward Drucas on behalf of Corey Jones.
Your name? Corey Jones. Thank you.
At this time, I'd like to set both these matters for exam,
All discoveries complete.
to my knowledge.
No other witnesses available the 23rd? Preliminary examination in person, April 23rd, 2026, 9 a.m. before Judge. Yeah. That'd be Garwood. It's Garwood. Bond continues.
Thank you, Your Honor.
Thank you.
Court calls case of the people versus Malik Asadi.
Overwater Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Shanazi.
Pardon?
Shanazi, I'm sorry.
I can really, you don't even know who you're, what?
I can't say her name.
What? Tanaza? I can really, right?
Yes, her.
Supervising it?
Yes, her. Mhm.
You're doing a very good job. Don't know her name. All right. I figure this is the last time I'll grant permission to you.
This is.
Well, it has been an absolute pleasure here.
Likewise. Likewise, thank you.
Starting up into practices today.
And we would like to adjourn in order to submit plea paperwork.
To
The-
plea paperwork?
Yes.
We just need. Where's your client? Asadi? On Zoom? Oh, not here.
Oh, sorry. Oh, thanks.
No, it's not your fault. I know whose fault it is, Miss Cannon. All right. You needed a to get the paperwork in.
Yes.
Probable cause conference will do April 16,
Or 6.
2026, 9 a.m. next week. Bond can-
Thank you, Your Honor.
Court does call the case of the people versus Chianti Jones.
Good morning, Your Honor. Edward Drucas on behalf of Chianti Jones.
Your name? Chianti Jones.
We'd like a preliminary examination, Your Honor.
Discovery is complete.
To my knowledge.
Would people have their witnesses available the 23rd? Preliminary examination in person, April 23rd, 2026, 9 a.m. before Judge Washington. 21st, I'm sorry. Where were we? April 21st are all of these. April 21st, 2026, 9 a.m. before Judge Washington. We're going to have to correct all of those other ones. Bond continued.
Thank you, Your Honor.
Court calls the case People versus Daryl Gardner.
Morning, I'm Raymond Cook for the people.
Ready, Your Honor. Robert J. Kilwell, Judge. I'm on case 0212 FY.
All right, thank you.
Assistant Public Defender Davy Lee also on behalf of Mr. Gardner.
Daryl, would you state your name for the record?
Daryl Gardner.
Thank you, sir.
Judge, on my matter, I'm asked to set exams.
And Your Honor, on my matter, we are waiving. Mr. Gardner, may I sign the form that I reviewed with you yesterday on your behalf?
No, we wasn't able to sign it, but I'm ready to sign it.
May I sign it on your behalf, sir?
Oh, yes, sir. Yes, sir. Yes, sir. Absolutely.
All right, that's the case of malicious destruction of personal or police property.
It is, Your Honor.
All right. On that case, Mr. Gardner, you're waiving preliminary examination.
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you could.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution on that matter.
Yes, sir.
People also waive their right.
Yes, Your Honor, there was an offer made on that case. And I put that on the record.
Yes, go ahead.
The offer was to waive up to circuit court on people that agree not to add an individual.
That is correct, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of the information. We waive formal reading and ask for a pretrial date, please.
Your client standing mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
April 20th at 1:30 for Judge Simpson.
April 20th, 2026, 1:30 before Judge Hamoud.
Thank you, Your Honor.
Excuse me. What time will it be, sir? What time will the court be? April
For
20th.
that case, it's going to be April 20th at 1:30.
At 1:30. All right. Thank you.
Before Judge Hamoud. All right, fine. We can continue on that case. And then on the other matter, discovery is complete.
Yes, Your Honor.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor.
Bound will continue. Thank you.
They're all coming to see you in a couple days.
All right, Bob. Thank you.
Thank you, sir. Court calls the case, People versus Walter Peterson, 2 cases.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Robert Ellman on behalf of Mr. Peterson on both matters.
No.
Mr. Peterson, can you please state your name for the record?
Walter Peterson.
Waiving on both of these matters.
That's correct, Your Honor. You should have 2 signed forms.
I do. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged in each case was committed and that you committed it.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
Will also waive the right.
Yes, Your Honor. Actually, this is an offer on the record as well.
May.
The offer was made to waive up to circuit court plea to the felonious assault charge in exchange for dismissal of the retail fraud, as well as there's an option being held open for the defendant to pay restitution on 2 other retail fraud matters in exchange for those cases not being.
Understood. Is that a correct statement, Mr. Elman?
Yes, Your Honor.
All right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we would stand mute and waive any formal reading.
And then having waived formal reading, standing mute to both cases, court will enter a not guilty plea. Pretrial will be set in each matter.
April 21st at 1:30 with Judge Conkey.
April 21st, 2026, 1:30, Judge Conkey.
Thank you, Your Honor.
Thank you. Bond will continue.
Bye. I'll talk to you soon.
Court calls case of the People versus Alyssa Arbiter.
Of waters is prosecuting the people.
Morning, Your Honor. Hannah Mackey, permission to practice under Michigan Court Rule 8.120 under Senior Public Defender Joy Gaines.
Under who?
Senior Assistant Public Defender Joy Gaines.
Oh, Ms. Gaines. All right, I'll let it go. Permission to practice is granted.
Thank you, Your Honor. Ms. Arbiter should be appearing via Zoom.
Ms. Arbiter, can you state your name, please?
Oh, she's muted.
Yes.
Elisa
Yeah.
Arbiter.
There you go. Okay. All right, what,
And we'd like to set this matter for exam.
discovery complete?
Your Honor, it was my understanding before that the previous prosecutor assigned to the case was going to possibly dismiss this case today. That's why we adjourned it last time. If no media existed to this point, there's still no media. The new prosecutor is on it. They just want to look into the case before deciding anything.
They want to what?
Look into the case to see if a dismissal is warranted or not, or what they wanted to do.
So what?
Honor, the video does not exist. We have the witnesses ready to proceed to exam.
It was relayed to us at last PCC that if no discovery was there, he would dismiss the case. And that's why we adjourned it again instead of setting it that time.
So we're just going to.
Yeah, so we're setting it now. But there's no media.
There's no further discovery of this.
No.
People have their witnesses available the 21st.
Yes, Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. That is before Judge Washington.
Thank you.
Bond will continue. Thank you, ma'am.
Thank you.
Court calls the cases of the people versus Mario Crawford.
Your Honor, Raymond.
Good morning, Your Honor. Veronica Glenn on behalf of Mr. Crawford. Can you state your name for the record, please?
Hey, Mario Crawford, Your Honor. Thanks. What are we doing?
We would like to adjourn for sobriety court screening.
For sobriety court?
Yes,
How far are we along on that process?
that is a very good question.
It's a good question.
Yes.
I know. That's why I asked it. Who are you looking for?
Cannon.
Bishop, can you find Cannon?
She's right outside.
Miss Cannon?
I'm not fine.
Mr. Crawford's just fine, but you left Miss Glenn up here without all of the information that apparently you may possess. What? What?
It was Joy's fault.
Nothing is Joy's fault.
Faster, guys.
Judge?
Stephanie Kane on behalf of Mr. Crawford. Your Honor, Mr. Crawford, I have been in touch with the staff. I think we've come up with a decent plan. There's paperwork that needs to be submitted that I have to get a signature on. He was supposed to have been screened for sobriety court. I didn't do that. It wasn't me, but now I know we're gonna get it done.
All right. How much time do we need to try to get all of that done so we can get Mr. Crawford's case moving along?
Your Honor, I'm gonna submit the paperwork today. I just need his signature in a couple of spots as it relates to that.
And somebody's going to have to make an assessment. Which sobriety court are we looking at?
Your Honor, I believe the one downtown would be better based on where he lives.
Got it. All right. Probable cause conference, I'll adjourn to April 30th, 2026, 9 a.m. Bond continued. Let's get it done.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Crawford.
All right, that was it, does.
Court calls case People versus Tony Bailey. You got to keep moving.
Your Honor, Raymond Cook for the people.
And I'm acting on behalf of Mr. Bailey.
Your name, sir?
Tony Warren Bailey. How you doing?
I'm doing great.
Long time no see.
Been a minute.
It has. How you been?
You're doing great. You? Probably could be doing better. Otherwise, you wouldn't be here like this, right?
Exactly.
All right.
Exactly.
Your Honor, we're adjourning this matter. We're just waiting for some media to come in.
Sorry?
We're waiting for media to come in.
How soon is that going to be?
Your Honor, I reached out to the officer. They
Video.
The video is cameras and that. Thank you.
have that is, so if they have it, they'll get to us quick.
Probable cause conference will be adjourned April 30th, 2026, 9 a.m.
Honor.
Continued. All right. Thank you, Mr. Bailey. Court calls case People versus David Grayson.
Hello, Water Assistant Prosecuting Attorney for the people.
Mr. Grayson,
So
I have names on this.
Yes, Your Honor. I apologize, Mr. Grayson. I did not hear your name being called. Good morning. Good morning, Your Honor. We are requesting an adjournment for Mr. Grayson. We are, and having reviewed our case file, we are in need of some additional discovery that we need to request from the prosecutor's office. I was just having Mr. Bishop and I were just in the process of doing the green sheet for Mr. Grayson, as you call it.
Read the green sheet. Can you state your name, please, sir?
David Richard Grayson.
Thank you. Probable cause conference will be adjourned to April 23rd, 2026, 9 a.m. Bond will can. Thank you, sir. Court calls case of the people versus Jeffrey Ball.
Are we ready to cook for the people?
Veronica Glenn on behalf of Mr. Wainwright. Oh my goodness. On behalf of Mr. Ball.
What's your name, sir?
Jeffrey Ball.
Thank you.
Your Honor, we would like to adjourn for mitigation.
How you doing? For this? How did that?
Probable cause April 30th, 2026, 9 a.m. Okay. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls case people versus Antonio Guy.
I'm ready to cook for the people.
Veronica Glenn on behalf of Mr. Guyton. Can you state your name for the record, please?
Antonio Guyton.
Sir.
Your Honor, we would like to adjourn for mitigation.
Is this the only case he's locked up on, or
This is the only case that we have.
only case that's holding you here, sir?
Washington County yet.
Pardon?
Who Washington County yet?
You have other.
Yeah, I got something in Wayne probation.
Probable cause conference April 23rd, 2026, 9 a.m. Bond.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case people versus Rashawn Bangora.
Yeah.
Prosecuting Attorney for the people.
Really? Where's Bukovich?
Spukovich.
So, Your Honor.
Oh, there you are. It's okay. Thank you for listening to me. You don't know who I called, do you?
Is it Mr. Bangor?
It is.
At this time, Your Honor, we are requesting an adjournment for the purposes of obtaining outstanding video discovery.
All right. Bangor? Okay, there you are. You turned on your camera. State your name, sir.
Arshawn Bangor.
Will the 30th be enough time for you, sir?
I think so.
Sir, I'm going to adjourn your matter to April 30th.
All right.
2026, 9 a.m. Bond will continue.
All right. Good looking. Good looking. Doing a two.
Thank you.
Doing a two. I know I'm doing a three.
Court calls the case. People versus Derek Hurd.
Jake Kennedy from People, Your Honor.
Ron, may I please the court, George Lyons appearing on behalf of the defendant, Mr. Hurd.
You got to get out of the way, Davey. Got to get through. Your name, sir? Hurd. Derek Hurd. Thank you. All right, what are we doing?
Respectfully, Your Honor, may we set the matter for preliminary examination? Unfortunately, I've been hearing you giving out the date for the week of the 21st. I'll be in a capital trial that week, Your Honor.
All right, we can work on that. Do you have all the discovery?
As far as I know, though I have not had the opportunity to speak with the APA to date, Your Honor, with regards to possible resolution.
We certainly have a conversation with the attorney.
It's all discovery complete. That's all I need to know. Will people have this available the 21st? Okay, but you're not available the 21st.
That's correct, Your Honor.
Would people have their witnesses available the 28th?
Yes, sir.
Will that work for you?
Judge, I'll make it work, Judge.
Preliminary examination in person, April 28, 2026, 9 a.m. That's before me.
It will be a pleasure, Your Honor. It's been a while.
Yes, it has. This time, behave yourself, though. No,
Your Honor,
just kidding.
Your Honor, no promises, but I'll try.
I got you. All right, take care. Fine, continue.
Thank you.
Thank you, sir. Court calls the case. People versus Troy Swope.
I need to speak to Brian. I didn't see him sitting back here. He's fascinating.
I'll pass him. Court calls the case. People versus Vernon Brock.
John Raymond Cook for the people.
I'm Anthony Brock via Zoom. Mr. Brock.
State your name.
Yes, I'm here. Bernard Eugene Brock.
I have before me a plea form that indicates the defendant will be pleading to an added count 2 of receipt and concealment, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also an indication that the prosecutor will recommend sentence under HIDA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
All right. Mr. Brock, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
State your name, please.
My name is Bernard Eugene Brock Jr.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of receipt and concealment of stolen property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No, Your Honor.
Looking at paragraph 5, you understand that those are your trial rights. You'd be waiving all those rights, including those rights contained under paragraph 5.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
Yes, I'm on probation.
Were you on probation at the time of this offense?
No. Wait.
You were not? Your counsel is indicating. All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes, Your Honor.
February 23rd, 2024, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty?
I was found with someone else's personal information, and I knew that it didn't belong to me, Your Honor.
Okay, so you got personal identifying information of another individual?
Yes, Your Honor.
All right, you took that information?
Yes, Your Honor.
All right. I'd have to accept a plea to the higher charge because I'm not sure how I'm going to have a value attached.
I think that's fine. I think there's also some additional factual basis that could be laid if necessary, but I'm finding facts is laid out.
Okay. Sir, I do have to advise you that if I accept your plea, that if you commit misconduct,
based on this being a misconduct offense. During this case, defendant was texting the victim friendly messages using his mom's phone to tell the victim. Some of the threatening messages included like you didn't see.
Yeah, so I was able to
Keep talking, you bitch. You gotta learn to call my name on your mouth. Don't be home. Victim, this is a reauthorization, Your Honor. So initially the cases were dismissed. However, defendant made the decision to continue his harassment of the victim repeatedly. And so here we are again. This time the case is not just going to disappear. So with all type honor, that is our.
Your Honor, at this time, I would be requesting a personal conscience bond on my client's behalf, as indicated by APA Townhall. This is a reauthorization. These cases were already litigated. He is here purposely availing himself to the court today to handle these matters. He is not running away from these matters, as indicated. He is here standing next to me right now. He does have full-time gainful employment. I do not believe there will be any issues of any no contact or no go to orders. At this time, Your Honor, based upon the fact that my client is here trying to get these matters handled on reauthorized cases, I believe a personal conscience bond would be appropriate.
Right. Well, as to the conditions of the defendant's release, I would indicate, first of all, that there is to be no use and or possession of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
You are not to leave the state of Michigan without permission of the court. I will also indicate that you are not to purchase, possess a firearm, ammunition, dangerous weapon, or anything fashioned to be a weapon. You understand that?
Yes.
You are ordered not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You understand that, sir?
Yes.
I will also indicate that you are not to have contact by any means whatsoever with Erica Jimerson Bird. You understand that?
Yes.
And when I say no contact, I mean absolutely no contact except with a civil standby. You shall not attempt to have any direct or indirect contact with that person, either through others or through yourself. You're not to do that with any electronic communication that's including but not limited to phone, email, texting, internet, and you are not to mention that person on social media or on the internet. You understand that, sir?
Yes.
I'm also going to indicate that you are not to go to the 8790 MacArthur Boulevard. You understand that?
Yes.
Except with a civil standby. You understand that, sir?
Yes.
You are not to violate any criminal law. You are to personally appear at all court proceedings. You understand that these conditions that I've given would apply whether you're in custody or you are released. You understand that, sir?
Yes, sir.
I am going to, for a review of the bond sheet everything. I am going to set the defendant's bond at about $50,000 cash surety on each case. Defendant is ordered remanded. If defendant is released, he's to be placed upon a home confinement GPS tether. Thank you. That's it.
It's guy. It's the diamond.
Court does call the case People versus Mamadou Diallo.
Hello, I'm here. Assistant Public Defender Don Filippo for Mr. Diallo.
Yeah, this is Mamadou Diallo.
Mr. Diallo,
Yes. Hello?
what? Mr. Diallo?
Yes, can you hear me?
Okay. Yes, now I can hear you, sir.
How you doing?
All right.
Karen, we're requesting adjournment. I have reached out to the prison where Mr. Diallo is housed, both by email and over the phone. Unfortunately, I've not been able to make contact with anyone at the prison. We have sent a letter yesterday that we hope will enable us to make contact with Mr. Diallo.
Mr. Diallo, I'm going to adjourn your case out April 30th, 2026, 9 a.m. or as your invite indicates. All right, sir?
All right. Is there any way I could take my lawyer's number real quick?
Okay, thank you.
Thank you, Your Honor.
All right.
Court calls case of the People versus Marcus Jones.
Depends on whether it's in the prosecuting attorney for the people.
Assistant Public Defender Don Filippo on behalf of Mr. Jones. Mr. Jones, can you tell the court your name, sir?
Marcus Jones.
You're requesting an adjournment.
I am, Your Honor, and I would also like to address bond, please.
Adjourn the matter to April 23rd, 2026, 9 a.m.
Thank you, and apologies. I did miss the date.
23rd.
Thank you, Your Honor. With regard to bond, Mr. Jones indicates that he does have housing he could stay at 727 Miller Avenue. Does tell me that he does urgently need to sign paperwork to maintain that housing. He does assure me that he'll work with CMH if released and will comply with any and all recommendations made by CMH. We would have no objection to attracting to the to assure appearance. And Mr. Jones has explained that his previous court date was missed due to a mix-up involving a date being rescheduled.
What date being rescheduled?
What Mr. Jones has explained to me is that there was apparently a date that was rescheduled due to a snow issue, and that as a result of that, he was not aware of the rescheduled date.
Response.
He's already failed to appear in court. His charge is resisting, so he's failing to comply with the order. So, please, we requested a bond of $5,000 cash secured at the time of this initial arraignment before he actually missed court. That bond remains as set.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Anthony Mullins.
And over water assistant prosecuting attorney.
I'm back on behalf of Mr. Mullins.
Let's see.
Mr. Mullins, unmute and state your name, sir. We can unmute him. There he is. Mr. Mullins, can you state your name? Lost the photo. I don't have a picture of him now.
Yeah.
Pardon?
Yeah. I think he's on the other side.
Mr. Mullins? I saw him for a minute. I'm going to pass that. I don't know what's happened. Court calls case People versus James Richmond.
Good morning, Your Honor. James Fifelski appearing on behalf of Mr. Approaching. Please.
Hi, my name is James Richmond.
Your Honor, all discovery is in. We'd ask the court to set this for preliminary examination.
People have their witnesses available the 21st.
Still in.
Preliminary examination will be set in person, April 21st, 2026, 9 a.m. That's before Judge Garwood. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Nyara Coleman.
Hannah Mackey on behalf of Mrs. Coleman. Again, Zoom, Your Honor.
Nyara Coleman.
Hi,
Hello. State your name, please.
Naira Coleman.
All right. What do we?
Your Honor, would like to set this matter for exam.
All discovery is complete.
Yes.
People have their witnesses available the 21st. Preliminary examination will be set in person, April 21st, 2026, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Bond continued. Thank you.
We'll be in touch, Ms. Coleman.
Okay,
Court calls
thank
the
you.
case says Andrea Tippins.
Morning, Your Honor.
Oh, he was here. You guys see Mr. Johnson? I saw him on. Your name, ma'am?
Andrea Tiffin.
Okay, your attorney was appearing via Zoom. He was on, but now I can't see. You don't see him in the waiting room. All right. So what I'll have to do, ma'am, is we'll take you back. I'll bring you back out once we get. Court calls the case People versus Castilian Cotton Roberson. Robert.
And Assistant Public Defender Nicholas Bukovich for Mr. Cotton Robinson, who should be over Zoom.
Sir, state your name.
Cotton.
Okay.
We'll be asking for adjournment for in both cases. A offer was extended. I just need time to discuss that with my client.
All right. I'll adjourn both of his cases to April 30th.
Yep.
April 30th, 2026, 9 a.m. Bond continued. Thank you, sir.
Thank you, Your Honor.
Court calls the case People versus Walker.
Your Honor, maybe quick people.
There is. David I. Goldstein appearing on behalf of the defendant.
Your name, sir? You're requesting a forensic.
Yes, Your Honor.
Forensic evaluation is ordered. I'll set a conference for
July 10,
9th.
9.
July 9th, 2026, 9 a.m. Bond will continue.
Are you ready?
Thank you very much. Court calls case People versus Mohammed Dari. You got to keep moving, sir.
Public defender, Shanazi Karat and Ruby, Your Honor, on behalf of Mr. Mohammed Dari, who is approaching.
It's 2 days in a row. 3 days in a row?
I was here Tuesday. How'd you get already?
It was more painful. This is a certain amount of pain. You're right.
You got a little glow today though, Judge, so
I'm sorry, what?
you had 3 doses of me this week. That's good.
Sometimes life is, all right. Sir.
Dari.
Your Honor, we're requesting an adjournment. I'd like to get some mitigation over to the people for Mr. Dari. There has been an offer extended, but I'd like to see if we could do a little better.
April 30th,
Okay, thank you.
2026, 9 a.m. All right. Thank you, sir.
Thank you, Judge.
Fine, continue. Well, court recalls the case of the people versus Anthony Mullins.
There's a water system.
Troy Kane, Senior Assistant Public Defender, representing Mr. Mullins. Your Honor, we're asking for,
Hold on a second. We've got your back, Mr. Mullins, but we're trying to get you unmuted here, sir.
All right, we
Okay,
should be good.
Yeah,
All right.
state your name, sir.
Anthony Mullins.
Thank you.
Your Honor, we are asking for an adjournment. We do not have discovery in this matter yet. We also are in the process of getting clearance so that we can meet with Mr. Mullins in custody.
Okay. So you're trying to get clearance to get through to meet with him?
Yes,
How much time would you need to try to get that done? Because
as well as to get the discovery. For the clearance, maybe 3 weeks.
okay, and then discovery. You want?
If there is
go
a
ahead.
plea offer,
What'd you say?
I say, I mean, I was supposed to already get home. If there is a plea offered, I'm sure there will be. I really don't have to see them. I could do that now. I'm pretty sure. I'm assuming it would be a plea to time served.
I don't.
and I would.
I don't know if there is an offer.
At this time,
Okay.
there,
So
Not.
thanks for trying to speed it up,
Okay.
but it's not going to work.
Yep, that's
Right.
all right.
Want the 30th or the 7th?
the 30th, please.
Probable cause conference will be adjourned April 30th, 2026, 9 a.m. Bond continued.
All right, thanks,
Thank you, Your
sir.
Honor.
Thank
Thank you,
you.
Mr. Mullins.
Yep, thank you.
Court calls the case of the people versus Lewis Gaines.
Ready, Your Honor.
Your Honor, Raymond Cook for the people.
Hoping no relation to.
Thank you. She didn't hear that, Your Honor.
Yeah.
I'm hoping not either. Right up here, sir. When you can make your way up.
Ricky.
Okay.
Your name, sir?
Louis Gaines III.
Thank you. All right, what are we doing?
Your Honor, we respectfully request an adjournment. I was just appointed on one matter yesterday, so to keep tracking together, I'd be requesting adjournment also, and I need to get discovery and review that with my client.
23rd or 30th?
30th, please.
Probable cause will be adjourned April 30th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, sir.
Well, that's it.
Court calls the case, people versus Vasquez Davis.
Your Honor, Raymond Cook for the people.
Assistant Public Defender, Tanaka Kiriaki, on behalf of Mr. Vasquez Davis, because he should be on Zoom.
Sir, state your name.
Yes, sir. My name is Vasquez Davis. How you doing today, sir?
I'm doing wonderful. Yourself?
Yes, sir.
Okay.
Judge, we're asking for, I do have a green sheet here. We're asking for an adjournment on Mr. Davis's case. The people have been very patient with us in regards to getting our mitigation information over to them. I do have a draft completed that I plan to send today.
Haven't complained about your.
They have not complained.
Okay.
The cook has been.
Oh, it's Mr. Cook. He's patient.
He is patient.
I'm not so.
I understand. Judge.
Okay. So how soon are you?
I will get it to him today, Judge.
Doesn't I want to?
Oh.
Now, I like this story. I didn't even talk late.
Probable cause will be adjourned April 30th, 2026, 9 a.m.
Thank you, Judge.
Continue. Okay, Mr. Davis. Thank you, sir.
Yes, sir. Have a nice day, sir.
You too. Court calls the case, People versus Deschardonnay Sander. Your case.
Good morning. And we have.
Your name?
Gardner Sanders. Your Honor, and have two requests. The first request is that both matters be set for a preliminary exam. And
Is all discovery complete?
yes, Your Honor.
We do have. Is. Get that with some. So I will get that sent to her ASAP. Not complete, but we do send her exam. I will.
Yeah, I don't think that would interfere with the time frame. We should have it by the exam.
Okay, you don't get an adjournment if for whatever reason it's not there. All right. Would the people have their witnesses available the 21st?
We'll do our best.
Preliminary examination will be set for 21st, 2026, 9 a.m. before Judge Garwood on both matters.
And the other request we have is my client would like me to address bond, Your Honor.
Go ahead briefly.
Okay, Your Honor, the chain of circumstances from the last bond argument is that my client is the caretaker for her uncle, Mr. Joe Robinson, who's actually in the gallery today. I've had an opportunity to speak with him. He's 82. He is having some liver issues that will require surgery. He's actually explained to me that he declined to have surgery at this time because Ms. Sanders is incarcerated. He explained to me that Ms. Sanders could live with him. We have the address here. It's local. She also has a friend of the family here, Mr. Benson, who is also here to support to ensure that she stays on the narrow. Ms. Sanders explains to me she's willing to go on a tether, and that she has been pursuing her education through Washtenaw County Community College. So we're asking that a bond reduction or a PR bond be allowed, Your Honor.
Response.
Your Honor. Bring this. Defendants teacher assaulted one involving minor issue. I would simply ask that the bond remain the same. Doesn't make the exam. Yeah.
It's my understanding that the children are not in the current 401 address where my client will be going to. I think that they're being looked after. There's also a neglect.
Whom?
I'm sorry, sister. Her sister. So she's not having any kind of direct contact with the children at this time.
Motion for bond reduction tonight. Bond will continue.
Thank you, Your Honor.
Of course, raise it after exam.
All right, thank you, Your Honor.
Court calls the case, People versus Amanda Dickinson.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender representing Ms. Dickinson. Your Honor, is Ms. Dickinson on Zoom? I received a message that she was having trouble getting on Zoom.
I have somebody, Amanda here.
Great.
Dickinson?
Hello,
Hello, state your name.
Amanda Dickinson.
What are we doing?
We would like an adjournment so that we can complete our investigation. I do have a green sheet for Ms. Dickinson here.
Probable cause conference will be adjourned April 30th, 2026, 9 a.m.
Thank you.
Thank you, ma'am. Court does call the case of the People versus Warner Ali Thomas.
What is this precedent?
Assistant Public Defender John V. on behalf of Mr. Ali Thomas. Mr. Ali Thomas, can you tell the judge your name, sir?
Warner Victor Ali Thomas.
In this matter, I have a plea form that indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing a first responder, police officer, first responder, that he would be pleading no contest to that charge, a 1-year offense. Upon his successful plea to that charge, counts 1 through 3 in this case would be dismissed. 15th District Court Case 260034, which is a trespassing case, would also be dismissed. 15th District Court Case 260048 SM would be dismissed. And count 2, 15th District Court Case 260033 would be dismissed. The defendant is also agreeing to plead to attempted resisting and obstructing in that 15th District Court case of 260033 SM. He agrees to pay restitution to be determined for all dismissed counts from the cases referenced in this document. There is also an agreement of a sentencing agreement that he will be sentenced to probation. That's the court's full understanding of his agreement.
And that is correct, Your Honor.
That is correct.
May I have him sworn?
Raise your right hand.
You solemnly swear and affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name for the record.
Warner Victor Ali Thomas.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of attempted resisting and obstructing a police officer or first responder. Is that correct?
Yes.
That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court.
Yes.
Basis for the no contest plea?
Lack of memory, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind. You signed an advice of rights form or had one signed on your behalf. Any questions regarding any of those rights? You understand that you're giving up all of those rights, the rights contained under paragraph 5. You'll see a copy on the podium.
Yes.
Search our rights. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
Court has been handed and has reviewed Ann Arbor Police Department report for their case number 268877. Any objection to the court reviewing that report?
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which to determine the defendant's guilt of these offenses. Sir, I do have to apprise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None known to the defense, Your Honor.
And have I complied with the court?
You have, Your Honor.
Court will accept the defendant's plea of no contest to count 4. Counts 1 through 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
April 28th at 9 a.m.
April 28, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor. And I did want to address that if possible. Thank you, Your Honor. Mr. Ali Thomas is currently being held on a $100 $10% bond in this matter. I believe that was set as a nominal bond arising out of it being held in the 3-3 matter in the 15th District Court, which is to be dismissed as a result of the agreement made today. He does have housing he would be able to return to upon release, he tells me. He additionally would like to begin looking for work. So for those of you that are trying, we would reduction to a personal recognizance bond.
Any response?
If we held on cases hasn't been dismissed yet, it's not such a house. It's maybe the court's discretion.
When is that case out?
It's already had,
I can check, Your Honor.
already had court with her yesterday. So this,
What, did they give you a new date?
yeah, it'll be Wednesday. I'll be seeing
This Wednesday?
I'll be seeing for the PSI.
He indicates this Wednesday, Your Honor, but I can double check that.
Wednesday? Well, what I'm gonna do, it's gonna be Wednesday. I'm gonna sentencing to the 28th. I'll grant it. He's not gonna get out at this point, but I'll set his bond to a $5,000 personal recognizance.
Thank you, Your Honor.
Record. He's up on the 15th, the RNO, but that case will not be dismissed. I think that's the case he's pleading to count on. That case will still be pending. I mean,
Right, but that's before Judge Garwood, right?
Correct.
So she'll be able to make a determination, but this won't be in the way because this one's not gonna get before her until the 28th. That's why we met.
Thank you, Your Honor.
Court calls case, People versus Michael Moore.
Morning, Your Honor, Raymond Cook, the people.
He in Zoom or is he here?
I'm sorry, he's here.
Okay. Do they have him?
God bless you.
You don't have him, that's, you got him or? Okay.
Mr. Moore. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Moore.
Your name, sir?
Michael Spencer Moore.
Thank you. All right, what are we doing?
Your Honor, we are in the process of contacting counsel for the misdemeanor matters that Mr. Moore has pending as well, in hopes of coming to a global resolution.
All right. So what do you wish me to?
We are asking for an adjournment. I thought I had done a green sheet on this matter, but I did not, Your Honor. Apologize.
Okay, this, here are the misdemeanor cases.
15th District Court.
Don't know when they're up. I mean, I can put this to the 23rd, but is
That would be fine.
able to,
Yes,
okay.
thank you.
I'll adjourn all these matters into April 23rd, 2026, 9 a.m. Hopefully we can get it moving. All right, bond will be here. Thank you, sir.
Thank you.
Court calls case People versus Destiny Skurlock.
Morning, Your Honor, Raymond Cook, the people.
An Assistant Public Defender Jay Bellinger on behalf of Ms. Skurlock, who is present via Zoom. Ms. Skurlock, can you please state your name for the record?
Destiny Skurlock.
Thank
And
you.
Your Honor, I have reached out in terms of an offer here. I'm just waiting to hear back, so I'm just requesting a brief adjournment on this.
Probable cause conference will be adjourned April 23rd, 2026, 9 a.m.
Thank you.
Bond. Thank you. Court calls case People versus Mary Pablo Well, bueno.
And Assistant Public Defender Chris Bukovich on behalf of Miss Mary Pablo Cabrera, who is now approaching. Once you get to the podium, please state your name for the record, Mary.
I'm Mary Grace and Pablo Cabrera.
Thank you.
At this time, Your Honor, will be setting this matter for preliminary examination. To my knowledge, all discovery is complete.
All right. And people have their witnesses available the 21st.
Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. That's before Judge Washington. Bond will continue. Thank you.
Your Honor.
Court calls case People versus Cameron Calvert.
Your Honor, reading the book for the people.
Carolyn Foster Tucker on behalf of Cameron Calvert.
Your name? Cameron Calvert.
And Your Honor, we're requesting an adjournment for time for defense to review discovery.
Probable cause conference will be adjourned 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. It's Court does call the case People versus Michael Payton.
Good morning, Your Honor. Jake Kennedy for the people.
Monica Glenn on behalf of Mr. Payton. Please say your name for
Your name, sir?
Okay.
Can you say your name for the record, please?
Michael Payton.
Thank you.
Your Honor, we would like to adjourn for mitigation and investigations.
And be able to get that done by the 23rd, or did you need another week? That wasn't a hard question.
It was. I had to think about it because I don't actually know the answer to that. Yep.
Your Honor.
The 30th? Okay.
Slow reading.
Thanks.
Thank you. All right, yes. Probable cause conference, April 30th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
It's okay. Cannon finally gave an answer to wake up first. Okay. Court calls case People versus Robert Dolan.
The door water assistant prosecuting attorney for the people.
Veronica Glenn on behalf of Mr. Dolan.
Your name, sir?
Robert Dolan.
We'll get him.
Thank you.
It's gonna change the plan.
Oh, now she's gonna be active and involved. Go ahead, what?
Your Honor, we are requesting an adjournment in this matter. And we will submit the green sheet momentarily.
Probable cause conference, April 30th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you, sir. Court does call the case People versus Diego Rodon Cardone.
Jake Kennedy for the people, Your Honor.
Floyd Gaines, Senior Assistant Public Defender, representing Mr. Cardone. Would you please state your name, sir?
Diego Rondon Cardone.
Cardone. Okay, right. Your Honor, we are requesting a preliminary examination in this matter.
All right. Discovery is complete.
As far as I know, Your Honor.
We'll have their witnesses available the 21st.
Sure.
Examination will be set April 21st, 2026, 9 a.m. before Judge Garwood. Bond will open.
Thank you, Your Honor.
Thank you. Does call the case People versus Dunlap.
Your Honor, reading the book for the people.
And Assistant Public Defender, Jay Bellinger on behalf of Jakia Dunlap, who appears via Zoom. Mr. Dunlap, can you please state your name for the record?
Dunlap.
And Your
I
Honor,
got it.
an offer has been tendered as of yesterday. Just need some time to go over that with my client, discuss his options. Just requesting a 2-week adjournment.
Probable cause conference, April 23rd, 2026, 9 a.m.
Thank you.
The room isn't so joyous without you in it, Mr. Bellinger.
I appreciate that, Your Honor.
All right.
You said is the
Thank you. Bond continued.
Thank you.
Court calls the case of People versus Jason Szymanski.
Your Honor, raise-
And I mean, we passed that matter, maybe.
Slow fashion.
Yeah.
I'll pass it. Briefly. Court does call the case. Oh, you got him. Szymanski.
Pass it.
Anyway, I'll pass. Court calls the case People versus Amber Dunson.
Water Assistant Prosecuting Attorney to the Peoples.
Assistant Blood Defender Davi Lieb on behalf of Ms. Dunson. Ms. Dunson, could you tell the judge your name, please?
Amber Dunson.
Thank you, ma'am.
And Your Honor, Ms. Dunson is going to provide me some additional information. We're also conducting some investigations. I'd request an adjournment for that reason.
Adjourn the matter April 30th, 2026.
Thank you, Your Honor.
Yeah. Thank you, ma'am. Bond continued. Court
Thank you,
calls the
Judge.
case versus Riley Everett.
Your Honor, Raymond Cook.
Assistant Blood Defender Davi Lieb for Mr. Everett.
Good morning. Your name?
Riley Everett.
Thank you.
And Your Honor, we're still working through some discovery issues. We'd request an adjournment.
What's that mean?
Discovery that people requested from Salim related to a different incident report that sort of it happens before this incident on the same day. We're trying to get a search warrant from them as well as some additional footage in a 911 call.
Got it. Why don't I do this if we're gonna May 7th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor.
Court calls case People versus Linnell Wall.
Take Kennedy for the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Wall, who appears in person.
Your name, sir?
Linnell Wall.
And Your Honor,
What are we
I'm just requesting an adjournment on this. The mitigation and investigation referrals have been submitted from my office. It's also my understanding that we still have no discovery on this case. I have discussed that with Ms. Tanha.
Okay. Is this the only thing holding him?
Yes, Your Honor. It is. It has been charged as a life offense case, though.
Correct. April 30th, 2026, 9 a.m.
Thank you.
Thank you. Thank you. Court calls case of the People versus Lawrence Fenderson.
Water Assistant.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Fenderson, who appears via Zoom, Your Honor. Mr. Fenderson, can you please state your name for the record? You'll have to unmute Mr. Fenderson.
Lawrence Fenderson.
Thank you, sir.
Your Honor, I have, our office has submitted a subpoena to the Menards involved in this case. We were told that there is video of this incident. They told us that. We are just awaiting that video. We're requesting a few weeks.
All right. I'll adjourn it to May 7th,
Thank you.
2026, 9 a.m.
All right, we have one more matter. It is in the matter of Christopher. Is it Joseph?
Yes.
It's yeah, this writ is misspelled. And Houston Smith. That's you.
Yes, yes, sir.
And Mr. Gertz is here, is your attorney, and the state's attorney is present. There is a motion or an application for writ of habeas corpus requesting a reasonable bond with the inference that the 800,000 was not reasonable. At least one man's opinion says that. Let me look at this circumstances. You know what I need to public safety report? I've got a public safety report here.
Thank you, Ellen.
You're welcome.
Good move, quickly.
And the people too. Well, put it on the website, please.
This is all he's been ever arrested for?
Yes, Judge.
That's true.
Yes. Yes.
You can speak up.
Yes,
Okay.
sir.
Sometimes help me on that. All right, generally, bonds are set based upon criminal history and circumstances of the offense. And then other circumstances become an issue. That is, if a bond is going to be posted, the ability to follow up with the requirements of a bond. Where do you live? I know where you're residing now, but do you live in Groves?
No, sir. I live in Needleton.
You previously lived in Groves.
Yes, sir.
I grew up in Groves. This is not what Groves stands for. All right. I think I see here why. Imagine who set this bond originally?
Judge Sharon, Judge.
I see why he would have set this. According to the probable cause affidavit here, law enforcement obtained warrants to get certain accounts that you were associated with to something called KIK Messenger, which I'm not real familiar with. But what they recovered, the police recovered, was a large amount of what they claim is child pornography that was associated with you here. The probable cause affidavit states that the writer, which is Detective Perkins of Needleton PD, observed 40 images and videos depicting child pornography, 31 of the videos depicting children being sexually assaulted. Further, according to this statement, the writer, Detective Perkins, the author of this probable cause affidavit, observed the suspect, you, to have uploaded photographs and videos of yourself to the account. And he was able to verify you by comparing the videos to your driver's license. Also, and probably the most disturbing part of this, I also, according to the detective, it was observed that you have communicated with other individuals on KIK, this system, system, about your sexual fantasies, which included sexually assaulting and murdering infant children. Can you explain that?
Judge, I'm going to ask him not to answer that question.
All right. Well, anything else?
No, other than I don't even know if the bond is sufficient as it is. But
One of the most disturbing things I've read in my career. And I've seen it all, I thought. And number one, child pornography continues to be abusive to the child. It continues to victimize children when it's out there. Child pornography is bad enough in its very essence. But when someone professes to, professes sexual fantasy of sexually assaulting and murdering infant children, that puts it into the potential harm and jeopardy of others in a new light. I don't think, and I've been a part of, from the Jamesburg murders to all types of crimes, but I don't think I've ever read such a horrifying and concerning statement about someone's thoughts, a human being's thought that murdering children would be amusing. Well, that's the inference. $800,000 is, I'm not lowering it. Judge DeRuin, I find, based upon the circumstances of this case, a fair determination. But if you happen to be able to post this bond, we have to have a hearing so that conditions of release would be appropriate based upon these circumstances, which would be a long list plus a list that would include all thoughts I would have to ensure that the safety of children could be preserved if you were released. And it would include at least home confinement, no access to internet. Are you married or single?
I'm married.
Sir?
He's married, Judge. Yes.
Okay. Any children? Do you have any children? Okay. Do you cohabitate with your spouse? Are you living with your spouse? He's down.
Oh, he went down on his first shot.
Oh, go ahead, Kitty, and that.
Yeah.
On his face.
Emergency medical services.
Radio. Please.
No. He passed out.
Relax. Radio. Thank you. Can I get up?
Don't get up, just sit.
Just sit. Start with four. Sorry, I apologize. You sit right there.
Where's he bleeding from?
No,
He keeps head up.
hit his face first, Judge. Luckily, he didn't do that, but he hit his face first. So.
Need some medical services. Thank you. Yeah, he's bleeding from face wound. All right, the jury. Are you ready? All right, we are in recess on this matter right now. Thank you.
Court calls case People versus Harold Watkins.
An assistant public defender, Jay Bellinger, on behalf of Mr. Watkins.
Your name, sir? Harold Watkins. Thank you.
Your Honor, I have reached out to prosecution in this matter. We are working on a global resolution. So I would ask for an adjournment. I would also request to address bond briefly.
Probable cause conference will be adjourned into April 23rd, 2026, 9 a.m.
Thank you.
Go ahead, Esteban.
Esteban, Your Honor, my client has advised me that he just returned from the state of South Carolina for purposes of taking care of these matters. He was unfortunately pulled over on a simple traffic matter. I don't believe he was charged. I think he was pulled over for speeding in that matter on his way to clear up these warrants. He advises that his cousin in South Carolina owns a security company and wants to hire him, but needs him to handle his warrants here first. If released, Your Honor, he plans to stay with his sister in Ypsilanti. He has a lot of family in the state of Michigan and in the local area. Willing to wear a GPS tether, does not plan on leaving the state as he attempts to resolve all these matters. He's willing to drug test, also comply with any other conditions as imposed by the court. So for that reason, we're asking for a PR bond.
Response.
People would object to a change of bond at this time. Looking at the ROA, I'm seeing the defendant failed to appear all the way back in 2022. And there was also a community corrections violation report filed at that time. Been on bench warrant status for the past 3.5 years, if my math is correct on that, but my math could be wrong. I believe given that failure to appear for multiple years, he does present a flight risk, and I object to change of bond.
I would agree. When the original warrant went out, he also had a community corrections violation at that time. So motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Ilya Finley.
Morning, Your Honor. President Strive, requesting permission to use practice pursuant Michigan Court Rule 8120 under the supervision of the student attorney.
How is he a supervisor? Just no words, huh? Okay, so permission to practice is granted. Go ahead.
And Matt, on behalf of Mrs. Finkley, please state your name. Aaliyah Finkley.
Thank you. All right.
Your Honor, we'd like to set this matter for exam and all discovery is complete as far as we are aware.
All right. Would you have your witnesses available the 21st? Preliminary examination will be set April 21st, 2026, 9 a.m. That is before Judge Washington.
Also, just wanted to make note on the record that we did request a 911.
Okay. All right. So no adjournment if those aren't in, but
Pardon?
no adjournment if those aren't in.
No, Your Honor.
All
I
right.
don't want to do extra talking since you just want to hear yes or no. It looks like.
Great. Okay. Thank you.
Have a nice day.
That is exactly how I feel. Kanaza, what'd you do to that baby? I know you did something. Go apologize. Yeah, all right. Court calls the case, People versus Joshua West.
Your Honor, Raymond Cook.
Assistant Public Defender, I was here, I can rule your honor on behalf of Mr. Joshua West, he's approaching. Listen, West, state your name for the record when you get to the podium.
Joshua West. Thank you, sir.
Your Honor, we respectfully request that this matter be set for preliminary examination.
All discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 21st.
Professor, Your Honor.
Preliminary examination, April 21st, 2023. 9 a.m. That is before Judge Garwood.
Thank you, Judge.
Thank you. Bond continue.
Oh, Judge Esteban.
Go ahead.
I'm sorry, Your Honor. Your Honor, we are asking that the court consider giving my client a personal recognizance bond. My understanding, Your Honor, is that his bond is currently set at 5,000, at 5,010%. From what we have seen, Mr. West does not have a criminal history at all, at least definitely not one in Michigan. He does report that he is looking for work currently, Your Honor. I've explained to him that he will not be able to go back to the place. This is a home where he shared, where the incident allegedly took place, but he understands that he won't be able to go back there. I've explained to him what a civil standby would entail, and he understands that. We're just asking that he be allowed to be.
Have a place to stay?
Not at the moment. I don't have my phone on me to call anybody right now, but.
So he just tells us that all of his contacts and everything is in his phone and lockup.
Yeah, he took it from me when I got arrested. When I got arrested, okay, sorry.
What I'm going to do at this time is I'm going to deny it. I wouldn't have a problem, I don't think, in this case, granting it if I knew where he would go. I don't even have a place that I could tether him to.
Tether him to, okay. We
So
can work on
I at time, but certainly it can be raised before the court. All right.
Thank you.
Okay, thank you. So it's bond will continue.
Okay.
Thank you, sir. Court calls the case, People versus Javon Foster.
Okay.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Foster, who appears via Zoom.
Sir.
Mr. Foster, can you state your name, please? Mr. Foster, we can't hear you.
Can you hear me now?
We can hear you now. State your name.
Hello?
Hello? Mr. Foster, can you hear us?
Hello?
Mr. Foster.
Hello?
Can y'all hear me?
Yes.
Okay.
State your name.
Javon
You
Foster.
can't hear. What?
Hold on. I don't know why.
State your name.
Javon Foster.
Thank you. All right. What are we doing?
Your Honor, I have been able to review all this discovery. It appears we're just missing one piece of the evidence, so I'm asking for a 3-week adjournment so we can see about getting that.
Your Honor, this is another one of those instances where the report indicates that the officer should have it on a disc. I'm just waiting for it to get to us.
Got it. Probable cause conference, April 30th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case, People versus Kyle Zimmerman.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Zimmerman.
Your name, sir?
Kyle Zimmerman.
All right, what are we doing?
Your Honor, I apologize for the delay. the mitigation specialist this week. So if we could have a
Life offense. Okay.
a 2 or 3 week adjournment, please.
April 30th, 2026, 90. Bond continue.
Thank you.
Thank you. Court does call the case People versus Jason Maples. And
Your Honor, for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Maples, who appears via Zoom from the jail. Mr. Maples, can you state your name from the record when you can?
we can't force them, right?
Yes,
All right.
Jason Jerry Maples here.
Thank you, sir.
Your Honor, I have reached out about a resolution in this case. My understanding is that Mr. Maples is also in the 22nd Recovery Court, so I'm just seeking a couple weeks so we can see about a resolution on this matter. This is the
Got
only
it.
case holding him. He's got $1,000 bond.
Got it. Probable cause conference will be adjourned April 23rd, 2026, 9 a.m. Bond continued.
Thank you.
All right. Thank you. Thank you, Mr. Maples.
Thank you. Have a good day.
You too. Court calls case People versus Stefan Brooks. Bruce.
Your Honor, Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant. Finally found out why the case hadn't been called earlier. They thought he was in Wayne County Jail.
Got it.
We managed to get him out.
Okay. Your name, sir?
Stefan Bruce.
All right.
Granted, because we were having a little game of hide and seek with him in the Wayne County Jail, I've not had an opportunity to discuss it with him resolution, so we can have an adjournment till April 30th. I'd appreciate it.
Probable cause conference without objection, April 30th. 9 a.m. Bond continues.
Thank you.
Thank you. Court calls case of the People versus Shannon French.
This is prosecuting three people.
Assistant Public Defender, Director, will be on behalf of Mr. Shannon French, who's approaching. Mr. French, Shannon, state your name for the record, please.
Shannon French. How you doing, Your Honor?
I'm good.
Judge respectfully requests that this matter be set for preliminary examination.
Dropping stuff on that. You want it set for prelim?
Yes, please.
All the, no, you didn't.
No.
I thought I could make it.
Sorry about that, Judge.
Sorry about that, Judge. Yeah, do everything right up here. Okay.
Your discovery is complete.
To our knowledge, Judge.
People have their witnesses available the 21st.
Don't see the reason why we wouldn't.
Preliminary examination in person, April 21st, 2026, 9 a.m. That's before Judge Washington.
Last time.
Thank you, Judge.
Thank you, Bond. So glad that's not before me. That could be a long day. Judge Washington is much more patient than I am. Court calls the case, People versus Andrea Tippins. This is brief.
Morning, Your Honor.
Okay. It's your name. We found him, Miss Tippins.
All right, thank you.
Finally located him.
That's fine.
I sent a bunch of people out to track him down. Mr. Johnson, can you state your appearance, sir?
Good morning, Mayor. Please, this honorable court, Kareem Johnson on behalf of Ms. Tippins.
Your name again, ma'am?
Andrea Tippins.
All right, what are we doing on this?
Yeah, I'm humbly asking this court for an adjournment. I have gotten information and discovered from the prosecutor's office. I need to talk to Ms. Tippins about some things, but I would like to address her bond as well, Your Honor.
All right. Will a couple of weeks give you enough time?
Yes, Your Honor. I was hoping the court could give me the 30th.
30th? Okay. I'll do that. Probable cause, April 30th, 2026, 9 AM. Okay, yes, as to bond.
Yeah, my client is indigent. These charges are serious. However, I believe that a mental health episode may have been what was at root of this issue. I don't know what all the court saw in the request for warrant, but she was, she left the bus. She was arrested without incident. This happened on the bus. I don't believe she made contact with anybody on the bus, especially to make contact with anybody on the bus with a weapon. So we'd ask the court to consider a nominal bond, considering her indigency, the fact that mental health may have played a role in this, and the fact that I don't think that she's a flight risk, Your Honor.
Response from the people.
John, I would agree with the characterization. There's a pretty significant mental health episode, but I do have concerns for public safety. This does not appear to be the first run-in with the law, especially in an assaultive matter. I am seeing previous convictions for felonious assault as well as assault and battery. Luckily, no one in this instance was harmed. If there were some way the defendant could get treatment either in custody or with a release to treatment, I think that would prove incredibly helpful for this defendant as well as resolution of this case. But I do have concerns for the public safety, given the nature of this offense, being that the defendant essentially tried to take the necklace off of a passerby on a bus with a knife. And I'll leave it at that.
Do you receive services from CMH?
No, see, cause I don't get any service around, cause I don't know where to go to for any mental service.
Got it. Okay, so you're just not sure where to go.
Not sure. I seen some places, but I wanted to stop by, but I just thought that there was for teenagers or children only. I'm 42, and basically
you're young.
Yeah, I'm just keeping myself together, not trying to prove the fact that I can act tough, but I don't want to do anything really stupid like take a life or a little piece of jewelry that I can go out and buy myself.
Okay, listen. I'll put it out to the 30th, but if somehow we can get her, I think she wants services.
Yeah, I want to
out where to go. Okay, so if counsel can try, I'll deny the request. I'll continue her bond at this time. But if counsel can get together and try to figure out how to get her hooked into some services, I would certainly consider some alternative in terms of incarceration, but some type of release. We just got to get her set up.
Yes, Your Honor.
Okay. All right. Thank you.
Thank you.
So hold it. Why are you here? No, not you. You don't ever come in here. Oh. Okay. Don't get disruptive. Go ahead. All right. Court calls the case, People versus Quadrant Gilliam.
Prosecuting attorney for the people.
And Assistant Public Defender Nicholas Bukovich. I'm having Mr. Gilliam, who should be appearing via Zoom.
I think he is. There he is. Sir, your name?
Quadric Gilliam.
Thank you.
And I believe I did submit a green sheet to Your Honor this morning.
30th work.
That will work for me.
I'll adjourn this matter April 30th, 2026, 9 a.m. bond continue. All right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Jason Szymanski.
Your Honor, being clerk for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Szymanski. Would you please state your name for the record, sir?
Jason Alexander Szymanski.
Thank you.
Your Honor, we do have a green sheet. We are requesting an adjournment. We have requested some media discovery by way of our legal assistant and are awaiting receipt, and we are doing further investigation with regard to some outstanding parole issues for Mr. Szymanski.
Check parole issues.
Yes, sir.
During April 30th, 2029 AM. Bond.
I think Mr. Smith.
Court calls case People versus Dontrell Smith.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender Chinazi Carey Akinruli, Your Honor, on behalf of Dontrell Smith.
Mr. Smith, can you state your name?
Dontrell Smith.
Thank you. What are we doing?
Today is the date and time set for a comp.
Yes.
Yes. We have received the competency report from Mr. Smith. We have reviewed it, Your Honor, and we do not have any objections to the report. Have you seen it? You have it?
And Your Honor, I received the report, looks like we received on April 6th. I would have no objection to the court reviewing that report and all other evidence.
It dated April 6th, or you received it?
We received it. Okay. The date is March 20th.
It's the same report that I have.
Well, that's great. Everybody's got one but me.
Oh.
I can forward a copy to the court print on off if the court needs.
Yes, if I, does anybody? I don't, yeah, I don't have it.
Okay.
I'll forward that to Ms. Whiteman right now.
Okay. I didn't say anything. Because every time I yell about somebody and a mispronunciation of your name, you get after me.
At 1:30.
All right. Mr. Smith, I should be able to get through that report rather quickly when they get it. So just hold on a second, Mr. Smith. We'll recall your case in a minute. Okay.
That was just sent over.
All right. All right.
Okay. Thank you. Court calls case People versus Sincere Godwin.
Public Defender Chinazi Carey Akinruli, on behalf of Mr. Sincere Godwin, who isn't here. State your name for the record, Mr. Godwin.
Sincere Godwin.
Judge, we're asking that this matter be set for preliminary examination.
Both cases.
Yes, both cases,
Discovery's late.
to our knowledge.
And people have their witnesses available on the 21st. Preliminary examination in person, April 21st, 2026, 9 AM before Judge Garwood on both matters.
Okay.
We'll continue. Thank you. Court does call the case People versus Darius Grady.
People, Your Honor. And Assistant Public Defender Jay Bellinger on behalf of Mr. Grady, who appears via Zoom. Mr. Grady, can you unmute and state your name for the record, please?
Darius Grady.
Thank you. And Your Honor,
Nice
an offer.
Go ahead.
Sorry.
Never mind.
Sorry, Your Honor. An offer has been tendered on this matter. I am just working with prosecution to work out some of the minor details on that. So we would just be asking for a few weeks.
Probable cause conference, April 23rd, 2026, 9 AM. Bond continues.
Thank you very much.
Thank you.
Thank you, Your Honor.
Thank you. Just look at this. And so I will, when I get a copy of an order, I'll
Yes.
sign that order. I'll set a competency review hearing for 90.
Okay.
July 9th, 2026, 9 a.m. Bond continued.
Thank you, Judge. I'll get that order over to you right now.
Thank you. Court does call the case of the people versus Stefan Wainwright.
Good morning, everybody.
Okay. Hello, Mr. Wainwright.
Stephanie Can on behalf of Mr. Wainwright. Your Honor, there has been a finding of competency in this case. I am not going to stipulate to it.
Or not?
No, Your Honor. It says, however, he declined to proceed evaluation, stating that he had already resolved the cases and was awaiting release from jail. None of that is correct. None of that is correct. He has not resolved any of his cases. This would be page 3, the first paragraph.
Okay.
He actually did not participate in the interview. He stated he understood who she was and apparently turned around and faced the door until somebody came and got him. And so he or she used previous information to say he's competent, and yet he thinks the cases have been resolved. How can my client help me?
Well, I don't know.
This
So
with that
what do you
finding?
want for me to do
Your Honor, I'm going to ask.
for a competency hearing, but
Your Honor, yeah, we can set it for an actual hearing regarding the matter of competency. I'm going to see if I can work with my office, maybe getting a second opinion. It baffles me that they were able to find him competent. When I met with him yesterday, he came in, looked at and stared at the metal table while I talked. And then that was it.
how much time would it take you to get that? I have orders for competency, but I've already signed those and they've already issued their opinion, so.
Your Honor, I'm going to see if I can get a second opinion on the matter. I will file the paperwork today.
So how much time do you think?
It'll probably take a week, maybe 10 days to get the approval, at which point we will submit the information to the court so that we can get it to our.
Well, why don't I do this? Give me a date.
It's the beginning of June, right?
Yes.
June 4th.
All right. I'll set this for June 4th, 2026, 9 a.m. If it looks like it will not be done, then that's for a contested competency hearing.
Thank you so much, Your Honor.
Bond will continue. Thank you.
Thank you.
Thank you, sir. That's that. Court calls case people versus Ye Greer.
Morning, Your Honor. Raymond Cook with you.
Good morning.
Anna Mackey on behalf of Mrs. Greer.
Greer, can you state your name, please?
Zaya Greer.
What are we doing?
Your Honor, would like to adjourn this matter. We're
Pardon?
still waiting for discovery.
Adjourn it?
Yes.
Do I get a green sheet or no?
Well, Miss Gaines was supposed to fill them out, and
Miss Gaines,
I've seen you wait.
do not try to throw her under the bus.
So I was hoping
This is all your fault. Miss Gaines would never forget.
just a few cases earlier, you waved her green. So I was hoping you could do this.
I was waiting for a green sheet from Miss Gaines, right? Yeah. Okay. We'll adjourn. How much time did you need?
We're just waiting for some discovery, Your Honor. So 2 weeks should be fine.
And Your Honor, I did reach out for that discovery actually back in March for the sheriff's office. I still haven't gotten any response from them. Yeah, I'm going to continue to reach out to them. I don't know how long it take them to get back to me on that. Hopefully.
Okay, so let me do April 30th, 2026, 9 a.m. at this point.
Thank you, Your Honor.
Bond will continue. All right, thank you, Ms. Greer.
Thank you.
Sure.
Court calls case people versus Mohammed Haji Jilani.
Assistant Public Defender Jay Bellinger on behalf of Mr. Galani, who appears via Zoom. Mr. Galani, can you please state your name for the record?
Muhammad Jalani, Your Honor.
All right, hello, sir.
How you doing?
All right, what are we doing?
Your Honor, we are just asking to set this matter for preliminary examination. All discovery is complete to the best of my knowledge.
Preliminary, and would people have their witnesses available the 21st?
Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
You, bond will continue. Thank you.
Thank you, Your Honor. Hope you have a good day.
Thank you, sir. You do the same. Court
Christine.
case versus Nicholas Harding.
Jacob Kennedy for the people, Your Honor. And Assistant Public Defendant Nick Buckridge on behalf of Mr. Harding, who is now approaching.
Her name? Nicholas Harding.
Yeah, and I do have a paperwork for Plea. Sorry, I was unable to get this in prior to this morning.
Let's just do this now. Why am I just getting it? It's not your fault. Don't worry about it. You're good. Buckovich? Whose fault is it that I'm just getting this?
To Mr. Buckovich's credit, he really did wear me down this morning, so. Yes.
Why are you trying to save everybody? Everybody, you know what? Fine.
And I wasn't gonna throw anyone under the bus, so.
You will when those tired threads go over you. But, all right. So what I have here is I have a plea form that indicates that the defendant will be pleading guilty to 2 charges, which is the stated count 2 of domestic violence, the 93-day offense, and to count 5 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to counts 2 and 5, counts 1, 3, and 4 would be dismissed. The defendant is agreeing to continue mental health treatment as recommended by his mental health professionals. There's also an agreement between prosecutor and defendant. Prosecutor will recommend the DV plea placed under 7694A, and that the attempted resisting and obstruction be a prosecutor's deferred sentence. That's the court's full understanding.
That's correct, Your Honor. That's correct, Your Honor.
May I have the defendant sworn?
Right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand. State your first and last name for the record, please.
Nicholas Harding. All right, sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges. Is that your understanding?
That's correct.
First of all, this court's understanding you're going to plead to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
I do.
All right. And also that you're going to plead to an added count 5 of attempted resisting and obstructing a police officer or first responder. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. You understand that?
I understand.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I understand.
Still wish to plead guilty?
I do.
To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form?
I did.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of them.
I do.
You understand you're giving up your right to appeal of right?
I do.
Are you on probation or parole?
Probation.
All right. Were you on probation at the time of this offense? All right. You understand that your entry of a plea in this case could be a violation of that probation. You understand that as such, that court could sentence you to the maximum allowable under those other charges. And understanding that, you still wish to plead guilty to these charges?
I do.
Has anybody promised you anything other than what's been stated here today to get?
No, Your Honor.
Anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will? And because you believe that you are indeed guilty of these offenses?
Yes.
On the date of November 4th, 2025, at the location of 1501 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do involving a Joe White Kwan that makes you think that you're guilty?
I made a threat while I made a pretty alarming threat to the individual under question.
All right. And this individual, and it would cause them to have fear that you would do something.
I'm sorry?
It would cause them to believe that you would do something to them. Is that correct?
Yes.
All right. And this individual you had a dating relationship with?
Yes.
All right. And did the police arrive at some point?
They did.
All right. And so you came into contact with Ann Arbor Police?
Mm-hmm.
Yes?
Yes.
Okay. And what happened?
It was under my assumption we were asked to leave the property and
leave Howard Cooper?
I'm sorry.
You were asked to leave the property?
Yep.
Okay.
And after some time, I was not well mentally at that moment.
But what happened with the police?
When they were trying to take you into custody after you were arrested, did you attempt to pull away from the police officers?
I did.
Okay. So you knew that they were trying to arrest you and you attempted to pull away.
And move away.
Yeah. Instructive they were trying to do. All right. So I do have to advise you that if between the time I accept your plea and the time of your sentence, you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. Understand?
I understand.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Okay, thank you. No, Your Honor.
And have I complied with the court?
We're satisfied, Your Honor. The defense is satisfied, Your Honor.
Court will accept the defendant's plea to counts 2 and 5. Counts 1, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 15th court probation. Sentencing will be
April 29th at 8:30.
April 29th, 2026, 8:30. That's before Judge Perry. Bond with its conditions will continue.
As we may address one bond condition, Your Honor.
One.
Yes.
Issue a bond?
Yes.
After you give me sheets late and everything? Sure, go ahead.
Yeah, Honor, my client would be asking for the consideration of removal of the tether. He has been on that tether since November without any other issues. He has been doing great work as it relates to his mental health treatment. That was a big consideration on why this offer was extended by the prosecution, the excellent mitigation report written by my mitigation team. So I would just ask for the consideration of the removal of the tether because it is, he has been complying on it since he's been placed on it, and it is producing a financial burden. I do understand if you want to leave that decision for the sentencing judge, and I did discuss that with my client.
Your Honor, Mr. Buckovich is absolutely correct that was something that how well Mr. Hardy has been doing and during the process of this case is definitely something that we considered when making this offer. Your Honor is more than well aware that Mr. Hardy has come to every proceeding, has been respectful, has done just about everything. I would defer to the court in this decision. I think there is a defendant.
I'll grant the request. And the tether may be removed.
You're welcome. Thank you.
Oh, you don't have to thank me. I'm talking to. So we'll release it. All right. We'll contact him. And so when you leave here, you can go over there and
to
community corrections and give it back to him.
Okay. Thank you so much.
Tell him Mr. Buckovich said, here, take this thing.
Do I need any?
Get real nasty with it, okay? No, you don't that.
The last time I was there, someone was in a similar situation. And do I have to have a piece of like paperwork or
piece of paper to do it? We're sending it over now.
So the court's sending it over directly.
Oh, okay.
All right. Okay. They won't take it off. It's Buckovich's fault.
Okay.
All right.
Thank you.
Have a good day.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, prison was fine.
It was your fault. I figured as much.
It's hard for me.
Haven't we all thought that? Court calls the case, People versus Devon Gibson.
Carolyn Foster Tucker on behalf of Devin Gibson. I've been informed of that. I was just going to ask for an adjournment for time for defense to continue its investigation.
I'll adjourn it out to May 7th, 2026, and then bond continued.
Thank you, Your Honor.
Thank you. Oh, that's good too. Court does call the case, People versus Robin Hardy.
Water assistant.
An assistant public defender, Nicholas Bukovich, I have Ms. Hardy, who should be appearing via Zoom.
Hey, can you state your name, please?
Robin Hardy, good morning.
Good morning.
I
I'm
could
requesting
barely
a-
hear y'all. Can y'all hear me good?
We can hear you.
Okay.
You can't hear me?
I could hear you. It's just, it was like the whole time it was kind of up, but like the volume went down, but I can hear you.
Okay. What are you doing?
At this time, I'll be requesting an adjournment. We're doing a little bit of an investigation to this matter, and I was put in an investigation request.
Probable cause conference will be adjourned to April 30th, 2026, 9 a.m.
April 30th at 9 a.m.
Yes. Talk to your attorney as to what time block you're in, but it's April 30th.
Okay, thank you.
All right, fine. We'll continue. Thank you.
Thanks so much, Your Honor.
Thank you. Court calls the case, People versus Robert Harris.
Assistant Public Defender Jay Bellinger on behalf of Mr. Harris. Your Honor, I was hoping Mr. Harris would be on Zoom. I did send him that information. I had contact with him as late as yesterday. To the best of my knowledge, he has not missed a court date. So, I mean, I would be asking for an adjournment.
Oh, so that's the standard if they don't miss? I don't really?
I think it may have just been a
That's the
misunderstanding. I think it may have just been a misunderstanding, Your Honor.
You think? You know, I thought it was going to be perfect for Bellinger since he wasn't in the building.
I normally try to get 100% of them there, Your Honor. That's more than
Yeah, I know
half the
you
battle.
do. Bench warrant, 10,000 cash surety. What I will do for you, sir, is I won't issue that warrant until the 13th.
Thank you very much.
Thank you. Court does call the case, People versus Brandy Hickman.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Donald Lee on behalf of Ms. Hickman. Ms. Hickman, can you tell the judge your name, please?
Randy Hickman.
Right, take your hands out of your pockets.
And Your Honor, we would like to set this matter for preliminary examination.
I don't need this green sheet. You're just.
Yes, Your Honor.
Yes, Your Honor, what?
Yes, Your Honor, you may disregard the green sheet. Thank you.
Is discovery complete?
It is.
People have their witnesses available the 21st.
Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor.
21st.
Bond will continue.
9 a.m. Second person.
I don't think I can take time off of.
Thank you, ma'am. Good. Wow. I am impressed by me. Why are you handing me more green sheets?
The ones from before.
Oh, the ones you didn't get to me.
Yes.
It's like a deck of, that's like a huge pile.
For 12:30 on the head.
Okay. Why did you get them to Miss Wife and in there?
All of the prior ones.
What did I say? What was? Buckovich, would you have questioned me if I had said that? That does that. We're actually going to get a break, which is good. All right, we'll court of state in recess till our next block. Thank you.
Okay, get summarize where we are on this.
Judge, Mr. Kirksey was convicted of aggravated sexual assault of a child a while back. He was represented by William Marcus Wilkerson, who's appointed for the case. He was in custody for a little over a year, unable to make a $100,000 bond. Notice of appeal was filed. The court appointed Douglas Barlow to represent him. I want to say about a month after that happened, I was contacted by members of Mr. Kirksey's family. They retained me for the appeal. I met with Mr. Kirksey, talked with him about his financial situation. He's without the funds to pay for the reporter's record. I was going to have I didn't have the affidavit of indigency with me at that time. I went ahead and mailed it to him at the Jefferson County Jail. That bounced back because he was transferred to TDCJ. He initially went to the Holiday Unit. I tried to get him an indigency affidavit there. By the time that arrived, he'd been transferred to the Bird Unit. So he's finally stable at the Bird Unit. He's just not eligible for visitation this time. If the court wants, I think that's his home unit for a while, so I can get that there. But my understanding is he's also got a felon in possession case out of this court. I did not check the docket this morning. I understand it's set for trial this month. Mr. Wilkerson is also on that case. I filed a motion for a free reporter's record. He's unable to pay.
In this court? He set for trial in this court?
I believe so, Judge, yes.
Okay.
It's awaiting the appeal. Usually the extra case kind of hang till the appeal is complete.
Oh, that could be years.
We'll move it.
Oh. Well, okay.
You know, I don't know how quickly the Court of Appeals is getting things out these days, but you know, I know the 1st, the 14th, they're moving pretty decently. Can't speak as much for my brains.
Stephen, what are you asking for right now today?
I am just asking for the court to order a copy of the reporter's record be provided for free because he is unable to pay for it. The family, I'm charging less than I normally would on this case. They were referred to me by another client on appeal. So
yeah, I'm sure you're being fair. The case law that I know about states there must be something from the defendant, some sworn document of some sort showing he's unable to pay. What is it? I've got Whitehead versus State.
Right.
Unsworn allegations were not evidence. A trial court can require a defendant seeking a free record for appeal or appointment of appellate counsel to verify his claim of indigence with supporting documentation. And that's what I've always done.
Yes, and I can tell you my standard practice is to always get an affidavit of indigency for the client. This has just kind of been the perfect storm where it's kind of like pinball. He keeps moving on me. So I have an affidavit from myself. I think that my affidavit plus the findings of indigency, both in this current case and in his other pending case, and his inability to make bond on either case is going to be enough. But if the court wants, I can certainly mail something to the Holiday Unit. I just think that probably the Court of Appeals is getting a little impatient with us. They're ready for this record and they want to get the ball rolling on the appeal. So I'll proceed however the court wants to. It's not me trying to pull a fast one. It's just they keep moving him on me.
Yes, sir. That's weird. Yeah, I just don't want to open a door of if once. Yeah, I do one for all, one for one. It's what's fair for everybody, and then they're going to say everybody's going to figure out a way to move around, I guess, so that they can get a free record. If we open the door, that's why we need something with his name on it, sworn saying he's indigent somehow. And can the family go and get one of those?
I mean, I can do that. It's just let's see how far away the Bird unit is. Let's see, he is in Huntsville. I mean, I can, if I mail something up to him for him to sign and return back to me, that's about at best 2 weeks, even just mailing from Houston, just because once that mail hits the unit, it takes him 3 or 4 days to get, and then he drops it and it takes a bunch of time to get back. So that's the slow way. I mean, if the court wants, I can burn half a day drive up to Huntsville and schedule an attorney visit and have him sign there and then do it. I'm fine doing it.
Can't you send it by mail? Can't you send it like overnight mail or something? And
I can. The only reason I haven't done that is because I didn't know how the court was going to rule at this time.
Okay.
So.
But somebody, the family or somebody needs to get to him to say when he gets it, he needs to sign it immediately and somehow get it. And then maybe the family can get it back. They can sign it. He can sign it there.
Oh, I can just have it sent to me. I mean, I can just type up an affidavit for him to sign, or if you want, I can just send him the indigency form. It's going to be kind of silly. It's going to be a whole bunch of zeros except what's on his account to buy, ramen.
I'm sure it will be. It's just, there's got to be something, though, apparently, according to these decisions that are consistent, that there some verification in writing that he's indigent. I can understand why, because if you don't, everybody's going to say that. Everyone would say that.
I hear you. I'll get something to mail to him today. Not a problem.
All right. Okay. And
I believe the Court of Appeals wanted the record. Kim, was it the 14th, 13th? The Court of Appeals will have to do an extension. I already did one. I think she'll have to have an extension for the Court of Appeals saying that, and we've already done one.
Get it to us as soon as you can.
Okay. I'll priority it to him today. Okay. Thank you, Judge.
Yes, sir. Thank you. Who's Christopher Flint?
Ryan.
I know. Where's Ryan?
People, if you want to skip to the other gentleman, while Ryan's.
Anchor Patel. Where's Mr. Patel?
Ryan's in back with everyone.
Oh, he's back there. Tyler Berry. It's going to be Jeremy Catrice.
Partridge, Judge, and that's close enough.
There you go, Jeremy. Let's see. What are we doing here?
Judge, this guy got arrested back in 2023, was placed on probation 2024 in Jefferson County. He got arrested. It's a deferred probation in 2024 for 3 years. He got arrested this past September up in Dallas County where he resides. So he's got a new offense. And so
6 months ago?
Yeah. 6 months ago, back in September, he got arrested. The state finally filed a motion to adjudicate. And of course, we finally figured that out and the warrant was issued. And I had him turn himself in on Easter Sunday. So he's sitting in the Jefferson County jail without a bond, and I'm looking to get a bond on him. The Dallas County case has not been filed all the way back.
You're Tyler Berry?
Yes, sir.
Okay, just stand right there, sir. Thank you. So your attorney is here, right there. You can see he's here. That's Mr. Cartridge. Mr. Cartridge. Yes, sir. All right. Go ahead, Jeremy.
And so that arrest in Dallas County from back in September, that Dallas County case has still not been filed, much less indicted. My client, he is a resident of North Texas up here in Collin County or Denton County. He's working in Dallas. And like I said, he drove all the way down to Jefferson County just to turn himself in and take care of this warrant. He's not going to have any problems showing up for court. He hasn't had any problems.
What happened on October 9th?
On October the 9th, what happened there?
He failed to appear.
So Judge, on October the 8th, I contacted Robert Menard of the Jefferson County Community Supervisions Department and talked to him about this issue. And I said, hey, what's going on? He said, man, a motion to adjudicate is going to end up coming. I said, well, why would we drive all the way down there for us to tell you that, yes, he did get arrested and we know that a motion to adjudicate is coming? Why don't you just tell him that we contacted you, tell him that we made the cost benefit analysis to say that we're not going to drive 12 hours and go ahead and issue the motion to adjudicate. And whenever that happens, we'll turn ourselves in, which is where we're at.
Well, y'all are setting the standards and the rules, not me or the rules. The rules are already in place. No matter what happens until he gets arrested, which didn't even happen until after January, right? I mean, this thing was filed January 2nd and he's not showing up on October 9th, 3 months. I mean, if I tell, this is what I've said for 20 years. If you can't do anything on probation, you got to show up, or else you're on your own probation, not ours. It's just, you got to report timely and regularly, or else we're unable to supervise you. And that's one of the allegations. That's always important. If you don't show up, you're not on really probation. You're on your probation, which in the way, that's tail wagging the dog. That's just not the way it should be. But it's still not a good idea at all to violate the very first condition, which is don't commit a crime. But what are we asking for today?
Judge, I'm just asking for a bond. His original bond back in 2023 was $5,000. It's usually double the bond is normally what I've seen on these things. And I think
not here. I mean, there is no standard for that here. I mean, it depends on what the circumstances are. I know it's double. State is here, Mr. Laird, and the probation officer is also here. So if you need to communicate with them, you're free to. Mr. Laird, on behalf of the state, I think he's entitled to a bond.
Yes, sir. He's entitled to a bond, and I cannot comment on the new offense in Dallas County. I don't have the new offense material. It hadn't been filed yet over there, so I do know that
it's a state jail felony.
It's
what they're saying. So
yes, sir. If he does have
it's
something
not violent crime,
I'd ask that he have a GPS put on so that we know that he's not frequenting places that might have solicitation.
Where are you going to live if you are released?
I have my own place, sir, in Louisville, Texas.
In where?
Louisville, Texas.
Louisville.
8801 Hebron Parkway.
Okay. All right.
And it's right next to my job.
Okay. From probation, anything we ought to talk about that we're not talking about that is related to his probation? All right. What are you asking for, Jeremy? How much?
A $10,000 bond, Judge.
Oh, I thought you said 5,000.
Well, 5,000 was the original one from 2023.
Okay. Well, here's what we're going to do: 7,500. Okay, I'm going to order a bond for 7,500. Plus, you're going to have a GPS device on you so we know where you are, so that when you're not reporting, we know where you are.
Yes, sir.
And is there any? Are you asking for home confinement on this?
No, sir. No,
I don't
that's
think
not
that's necessary under these circumstances. Okay, so if you post a bond, you get out of here. What are you going to do during the day?
I have a job, sir. I'm
What do you do?
Internet manager at Finland Chevrolet since the fall of 23. So coming up with.
So what are you doing here? You got a responsible job.
Yes.
And responsibility to a family, I guess. Fix this.
Yes.
Fix it.
The past 6 months I've been in therapy for it. And I also going to church and got a Bible study and found Christ.
How's that working?
Amazing.
Oh, good.
I also got a divorce and it's been
how's that working?
Amazing. We're great co-parents. we were in a miserable marriage.
Oh, okay.
And I found God in the church. I go to Bible study every Wednesday and I see my therapist every Monday. And I'm an award-winning car salesman doing my best to stay out of jail. I know I made a mistake.
Well, it's fixable. That's the test of character. Everybody makes a mistake. Everyone in here has made a mistake. Defendants and other. It's how you fix your mistake. That's the test. Are you going to fix it? And responsible? Good. And that's the test of character. Okay. All right, do better, and that's gonna be the order of the court. Next event is, he'll post a bond, he'll get out. We're gonna have what, an announcement?
Yes, sir. So they get time to see what's going on with Dallas.
Ellie
We can
is
talk.
one of my coordinators. She'll send you something on the next event here.
Yes, Your Honor.
Okay, anything else?
I don't, just want the, on the GPS, Judge, is there any way we can have that monitored? He reports up in Collin County every month. Is there any way we can get Collin County to maintain that GPS?
I don't know how they do that. We've always done it, because I never thought another probation officer.
Usually the bonding company kind of keeps an eye on things, and if there's an issue, then we all look at it and see what's going on where he is.
Okay. So just as long as he keeps it charged up, we'll be good.
Yes, sir.
Okay, that sounds great.
Yeah, don't lose the charge on it. Sometimes it bleeds out fast, but keep the charge so that, because if it discharges, then there'll be an alarm that'll be set off of where are you? Where's Waldo?
And the target will work, because I don't, parcels on there.
No, I think it's chargeable.
8 to 8, that's what usually.
Yeah, I'm sure.
And he doesn't have to wear it while it's being charged, is it? Does he?
Yeah,
Does he?
it's,
Okay. I do it at night.
I think probably, but stay.
I think, don't they do it at night, Jen?
Yeah, I mean, it should look like all day.
How long does it take to charge that?
Like all day sleep, so. They just have.
Takes a few hours. Do it at night when, yeah, it's a pain. Just don't walk in your sleep.
Yes, Your Honor.
A long way. Oh, okay. We'll get a resetting to everybody. Okay, thanks.
Thank you, Judge.
Thank you. Yes, sir. Christopher Clinton. Now that you're walking around.
Since I'm here.
You're ambling about.
Just as a brief reminder, this is a case that it's about sex offender registration, and we have a pending civil matter about having people required to register it's pending in Austin. And so
Where are we on that from the state? Which we're still pending?
Still pending, yes, sir. So as long as he's doing what he's supposed to do right now, just kind of leave things as they are till we see.
Oh,
Yes, sir. There's
something that was filed a long time ago.
this has been a lot of hearings and a lot of meetings, and so they're going through the civil process to see.
as it turns out, Judge, the law requires to make a determination about whether or not somebody's required to register. You have to do that in Travis County for some reason. And so we've had that pending for a while in Travis County.
What's the prognosis on it? Where are we headed?
Well,
when
one of the challenges is the judge that we had before that had all the hearings about everything got elected to the Third Court of Appeals. And so we had a new judge, and we've changed people at the Attorney General's office. And so it's just been like pending.
I can't believe the government would act slowly.
I know, shocking.
So, well, I mean, so
Right now,
what do we know?
is he registered right now, or is he not?
Yeah, he's complying.
Okay, as long as
That's
he's
the most important.
as long as
thing
he's
for me.
compliant right now,
That's
Judge, we're
true.
holding the pattern until we figure
Don't
this out.
miss that.
Yeah.
I think we're good as long as we keep that up.
I guess, what do we review it in a couple of months?
Perfect.
All right.
Thank you.
No problem. No.
Yeah.
Anchor Patel? Anchor? Hold on for just a second. Let me do Marvin's stuff first, okay? And then we'll go. Because Ryan, you're gonna be here for a while today.
But I got all the information.
I don't know. That's the word on the street. On Donald Barnes, Marvin, what are we doing?
Judge, on this one, he is, he's trying to hire a new attorney. So I filed a motion with withdrawal. I thought it would have something about that. It's like, you file a motion.
Okay, Donald Barnes. We need Donald Barnes. Thank you.
I know what's coming. I'll figure out. Yes, ma'am. Thank you.
Well, here's the deal is. I mean, we can hire one, but we've got a motion to revoke probation. That's just pending. You're still the lawyer. Why don't we move
Yes, sir.
forward?
But there's on that new offense, I believe, since it was September of 25, they're still testing the controlled substances. So even if we wanted to go forward, all we could do is just point our finger at him.
The test. I'm going.
Test is back. So
What were you saying there, Mike?
They still haven't filed it yet.
That's what they filed, and they wanted it to be filed.
They're upping the charge on it, so it hasn't really
Who
been
is-
filed with our office. It's the police department came in, brought it to our office. They looked at the amount of the drugs and
It
everything.
was
and
higher
they-
than before?
Then they decided to refile it as a higher charge. So
When will that happen? Well, I mean, does
well,
that,
within the next
does that stop? you
within the
from-
next couple of weeks, but
So I guess you're gonna amend the motion to revoke probation? Is that what the state's
Stay with the current motion to.
depends on how they file it.
okay, so what's stopping us from then just moving forward on that motion to revoke probation?
Evidently nothing. Mr.
Well,
Hans wants to
Okay, but
have a
what is,
hearing really
what's he
quick.
wanting?
He even wants a new attorney.
Well, okay, until you can hire your own.
Right.
But I'm not, he's a competent lawyer. This man's a competent lawyer. We're gonna move forward on a motion to revoke probation. You've got the other tampering or fabricating evidence, new charge. But we're gonna go on the motion to revoke probation first. And you can either represent yourself, which would be unwise if you don't want Mr. Lewis, but he's a competent lawyer. You can hire somebody anytime you darn well want. And
Yes, sir.
we welcome that, but you've got to do something quickly, but I'm gonna set it for a hearing here in Mr. Laird, can y'all be ready in 3 weeks? All right, well, y'all got 3 weeks and we'll set this, but you can hire somebody. If you hire somebody, they better be ready for the hearing.
All right.
Okay, all right, that's it.
All right, thank you.
Thank you. On Mr. Christopher Smith matter.
It's mine, Judge.
That's yours?
I filed the writ, so.
It's indicting.
Okay, it's Mr. Patel.
Yes, Judge.
Come on up. Just stay.
Hearing on it.
Good to see you. Okay, let's see, this. Yeah, it was a matter, as the court recall, when the defendant was. So placed on probation, right?
Do you know, Judge?
No.
This was a jury trial where the jury gave him 2.5 years in prison, and then
Okay.
they asked for an appeal bond. We had a hearing. You told him that if he would go get treatment, you might reconsider it. And so he went off and did treatment.
Yeah.
He
It
successfully.
was a
completed
90,
his
it was
community
about
rehab.
90 days. So what we have is, this was based on a motion to set an appeal bond filed in December. And then the court ordered that we go to a facility for treatment. And for at least 90 successive days, which it looks like that has happened.
Yes, Judge.
And there's no report or anything. Well, I guess
That's my problem with this whole thing is we don't have anything from the facility saying how he did. We just got he's out after 90 days.
Yeah, I can get something.
we can,
My-
any day you did it, do it, and we'll come back.
Okay.
But we gotta get something that shows, I'd like to know, especially for setting other terms and conditions.
We may have it. Okay. As you know, I've been a little busy in here, so,
I don't know if you know that, but I've been busy.
you've been watching and judging. You see, you emailed it to me or to Randy? Okay. Okay, so she probably.
As amusing as this is, watching you fiddle with your phone and attempt to pull out an email or a text, there is something.
There is.
You're not just typing something in right now.
Using that AI generator, are you?
Where is the
Texting is saying it's
appeal? What's the appeal? Have y'all filed
We
a,
filed a notice of appeal. I think we,
when's the brief due?
I don't even know that we have a briefing schedule yet, Judge.
What's a problem?
Hang on, this.
Being set for misdemeanor 4/30/27.
For his MTRP on his misdemeanor.
Yeah.
Okay, I'm looking.
Did you?
Good morning, Lewis's response.
No.
Is that one?
No, this is the dismissal, and this is the.
Oh, Lawrence.
This is the one we haven't done.
Oh.
The other one is a dismissal that I'll give you in a minute.
Let you look for it. I'll look now.
Hey, Kendall, could you tell the jury we're going to need about 10 more minutes, please, and thank them for their patience. Thank you. Is this all there is? It's a succinct, just this?
Yes, Judge.
That one paragraph?
If you,
Okay.
if you move the.
Is there more to it?
I don't know, but if you use two fingers
On the screen.
up and down on the mouse, no, it doesn't.
On the mouse, you have to do that way.
In the past.
You don't have a touch screen. $100 lawyer like you.
Well, no. Oh, I see. You got to move it up for it to go down.
Enter twice to exit, Judge.
I want to see how you drive a vehicle. You down Interstate 10 in reverse? Is that what you do? You're going down Interstate 10 in reverse?
Reverse, you push forward on the lever, you want to put it in drive and pull back. I don't know.
I need this to be converted to something in writing. So fine.
Ellie's printing a copy.
Ellie's printing a copy, Judge.
Well, I don't find.
You do too.
We're just gone from galleries.
You and Jimmy.
All right. So this is a 12-step program. What they're saying, he's gone through 9 steps. What about, and I'm not really familiar with what steps 10, 11, and 12 are.
Yes, Judge.
Since I've never really seen what those are. I don't know what that is. What are they? And it's obviously not part of the inpatient. So is that right?
I would
Is it an outpatient?
Outpatient aftercare that he's doing.
Can I find out what that is? Can anybody, real quick?
If you hand me the computer, I'll find it real quick. Look for you.
Okay, it says, and completed his 8th and 9th step amends process. As a sponsor and continues to utilize sponsor upon discharge, successfully completed treatment episode on April 8th. So 4th and 5th step. And 12 steps that covers the program. I just need to know what's
next.
Well, what steps are still required?
So it's, sorry,
Yes, ma'am. Go ahead. Do you know?
it's a 12-step process. So like AA.
I knew that.
Well, it's
What are they?
they're the.
What's still left?
So he'll go to AA meetings and that's part of their step process. So he made amends and then the last few steps, he'll continue working with a sponsor to complete, last 12 steps of recovery.
Right. And Judge, the last step is kind of a continual step, which is that you essentially will eventually become a sponsor and sponsor other people and serve the process of sponsoring the people. And that may have been what you just said, essentially. Yeah.
All right.
Probably sound better.
Okay. All right. What else are you asking on this?
Judge, we're just asking that you, as a practical matter, you set an appeal bond. He posted the appeal bond and went and did the 90 days that you asked him to do. So now we're asking the court to maintain that appeal bond, I guess is the best way to say it. Chris Romano has the bond. He will do interlock or scram or whatever you want to do on that front.
Of course, we objected whenever this happened. We still object because he was on probation at a misdemeanor court when he committed this offense or DWI third. And so
here's what we're going to do is I'm going, I agree with the concerns of the state. I'm going to release you on this bond. You must complete timely the full 12 steps in the recovery program that in this intensive residential treatment plan that you attended that still are required of number one. Did I set a bond of amount?
You did, Judge. He posted it. I don't know how it works because he had to turn himself back in. So I don't know.
Revoked the bond yesterday.
Oh, okay.
Complete it.
Okay.
In order for him to get back into custody.
Okay, I got it. I got it. So he'll have to repost that bond, I guess.
The bond shall be reposted. You shall not operate a motor vehicle at all. Number one. Find that you drive a car, an automobile, or any mobile device that's on the street, whether you're intoxicated or not. It will be a violation of your bond. Number two is there's no alcohol. And the scram device, I guess, is what we'll use for that.
That's fine, Judge.
And trying to think of some other terms because I want to ensure that I know if you've got a scram device, but do we have something that can show if there's alcohol in the system?
That's what the scram
will do. What other conditions?
Judge, that's the main problem is he hasn't had any other criminal history that I'm aware of.
No.
It's just been the
No,
I'm intoxicated.
but this is serious.
Yes, sir.
You got that car stuck on the stop on the freeway. That's a 4,000-pound missile. And you didn't even know what planet you were on. But this has happened before. You didn't fix it. Here you are. And you're supposed to be a role model in the community as a business leader, sir. This is not setting a good example. Fix that, please.
Yes, sir.
Okay. For the safety of yourself and all others.
Yes, sir.
Are there any other conditions from pre-trial services that we need to?
Possibly home confinement. If you want him to stay at home and not go anywhere whatsoever.
Judge Hart.
That way there's no issues about him traveling.
Yeah. Well, a GPS device will show where he is.
Yes, sir.
And I want you only to go from home to work in the most direct route possible. You can go from home to a hospital if you need medical care. You can go home to a place for food if you need food, and home to church, religious
worship,
mass or worship in the most, and all of this is the most direct route possible, and to and from the attorney's office.
And then also AA meetings, Judge, or outfit.
Well, if it's required,
Yes.
Yeah, he's got to get to that, and he can't fly. So you would have, if you're at Alcohol Anonymous or other programs that are part of this recovery process, you are allowed to go there to and from in the most direct route possible. But again, if you, unless you walk to, you can't drive a vehicle. Somebody is going to have to operate a vehicle. I want to review it in 4 weeks, every 4 weeks, to see how things are on this, because it's intensive, but it deserves attention. Constant attention by the court. Are you able to follow all these, sir? Yes. Okay. Anything else on this? State and probation?
Yes, sir.
Thank you very much, Reverend Sasser. All right. Christopher Smith? Add on. Okay.
Thank you.
You follow Red?
It's just my normal. They use 8,000.
Normal Red?
Yeah.
Can't appeal a motion.
All right, we have one more matter. It is in the matter of Christopher. Is it Joseph?
Yes.
It's this Rid is misspelled. And Houston Smith. And that's you.
Yes, sir.
And Mr. Gurgis here is your attorney, and the state's attorney is present. There is a motion or an application for writ of habeas corpus requesting a reasonable bond with the inference that the 800,000 was not reasonable. At least one man's opinion says that. Let me look at this circumstances. You know what I need to
There.
public safety report?
Look there.
I've got a public safety report in.
Thank you, Ellen.
You're welcome.
Good move, quickly.
And the people too, just, when I'll put it on the website, please.
This is all he's been ever arrested for?
Yes, Judge.
That's true.
Yes.
Yes. You can speak up. Okay. Sometimes helping on the. All right, generally, bonds are set based upon criminal history and circumstances of the offense. And then other circumstances become an issue. That is, if a bond is going to be posted, the ability to follow up with the requirements of a bond. Where do you live? I know where you're residing now, but do you live in Groves?
No, sir. I live in Needleton.
You previously lived in Groves.
Yes, sir.
I grew up in Groves. This is not what Groves stands for. All right. I think I see here why, imagine, who set this bond originally?
Judge Sharon, Judge.
I see why he would have set this. According to the probable cause affidavit here, law enforcement obtained warrants to get certain accounts that you were associated with to something called KIK Messenger, which I'm not real familiar with. But what they recovered, the police recovered, was a large amount of what they claim is child pornography that was associated with you here. The probable cause affidavit states that the writer, which is Detective Perkins of Middleton PD, observed 40 images and videos depicting child pornography, 31 of the videos depicting children being sexually assaulted. Further, according to this statement, the writer, Detective Perkins, the author of this probable cause affidavit, observed the suspect, you, to have uploaded photographs and videos of yourself to the account. And he was able to verify you by comparing the videos to your driver's license. Also, and most probably the most disturbing part of this, I also, according to the detective, it was observed that you have communicated with other individuals on KIK, this system, system, about your sexual fantasies, which included sexually assaulting and murdering infant children. Can you explain that?
Judge, I'm going to ask him not to answer that question.
Oh, well, anything else?
No, other than I don't even know if the bond is sufficient as it is. But
One of the most disturbing things I've read in my career, and I've seen it all, I thought. And number one, child pornography continues to be abusive to the child. It continues to victimize children when it's out there. Child pornography is bad enough in its very essence. But when someone professes to, professes sexual fantasy of sexually assaulting and murdering infant children, that puts it into the potential harm and jeopardy of others in a new light. I don't think, and I've been a part of, from the Jamesburg murders to all types of crimes, but I don't think I've ever read such a horrifying and concerning statement about someone's thoughts, a human being's thought that murdering children would be amusing. Well, that's the inference. $800,000 is, I'm not lowering it. Judge DeRuin, I find, based upon the circumstances of this case, a fair determination. But if you happen to be able to post this bond, we have to have a hearing so that conditions of release would be appropriate based upon these circumstances, which would be a long list plus a list that would include all thoughts I would have to ensure that the safety of children could be preserved if you were released. And it would include at least home confinement, no access to internet. Are you married or single?
I'm married.
Sir?
He's married, Judge. Yes.
Okay, any children? Do you have any children? Okay. Do you cohabitate with your spouse? Are you living with your spouse? He's down.
Well, he went down on his first shot.
Oh, go ahead, get him there.
Yeah.
Look on his face.
Emergency medical services.
Radio. Please, please.
No. He passed out.
Just relax. Check the radio.
Don't get up, just sit.
Just sit on the floor. Sorry, I apologize. You sit right there.
Where's he bleeding from?
He
keeps head up.
hit his face first, Judge. Luckily he didn't do that, but he hit his face first. So.
Need some medical services. Thank you. Yeah, he's bleeding.
Yeah.
From face wound. All right.
The jury.
All right, we are in recess on this matter right now. Thank you.
Honestly, I don't know because she was not a respondent on the petition. It was a dependency petition. And so I'm not sure that she was given the notice.
Okay, well, it's 12:32, so let me call the case and then we'll get started. This is the matter of Gabriella Hall, file J26-397-NA. Mr. Summerfield, if I could have your appearance, please.
Sorry, Judge. Don Summerfield for the Department of Health and Human Services.
I do see Ms. Mathias from the department is with us as well. This is the first hearing on an emergency take and place order that was done last night in regard to Gabriella. Ms. Mathias, could you inform the court of what transpired from last night to this morning?
From last night, yes, we went down and picked Gabriella up from Cedar Creek Hospital, and we brought her here to, she actually was in a treatment foster home for one night. They had availability for one night. And so she went to a treatment foster home in Kalkaska last night. And we are working on placement moving forward from here.
All right. Before we came on the record, I asked you about notice to mom. If you could tell me what, if any, contact you've had with the mother and what attempts at notice, if any, you've made.
So we've had contact with mother throughout this process. She's aware of the petition being filed. We had brief contact with her by phone this morning. She was traveling out of state, their family emergency with her mother. So she was traveling out of state. We did have contact with her regarding Gabriella's medications and had her sign a form that was needed for that. So she was aware, but I don't believe at that time when we had contact with her that we knew what time the hearing was today. We can certainly provide her notices of hearing moving forward, and I would not anticipate any issue with her participating in future court hearings.
All right, thank you.
Judge, can I make a record about this?
Absolutely.
Yes. This is a very unique gray area in the law. And I say that because there's a Supreme Court case that came down April 14th, 2025. It's called In the Matter of Lang. It's DVL and then LANGE. It has a Supreme Court number of 166509. I'm not sure if they have a citation just yet. That'll get you to the right place. What happened in that case is so similar to the facts in these cases. And I'll explain what happened in that case is that the child, much like in our case, had severe mental and emotional problems, hospitalized, CMH, just a history of violence, much like that is alleged in our petition for Gabriella, I'm sorry. And what happened is that the same situation occurred. The child was in a secure environment. Like in our case, it was that listening ear. It was listening ear foster home through community mental health. And much like in the DVL Lang case, there was going to be a discharge and a date. And what happened in the Lang case was that mom, based upon the history of, the child was very violent. Just there had been so many instances of physical, emotional, and mental abuse that she said, I can't do this. I can't, we've been taking our child to different places to get her help. And then they're like, well, the child's fine. And then you can come and take her. And it's like, I can't do this because I fear for my own safety. It's very similar, almost identical to the facts in our case. Well, what happened in the Lang case is that there was a petition filed, and the trial court denied the petition based on the removal statutes of MCL 712A 2B1 and 2B2. Those are the normal ones that we generally use. Those are the parent or other person legally responsible for the care and maintenance of the children. And this is important when able to do so. Neglected or refused to provide proper and necessary support, education as it goes on, or other care necessary. And then the home or environment by reason of neglect, cruelty, drunkenness, criminality, and depravity makes, it's an unfit home. The trial court in Lang said none of those statutes applied and denied the authorization of the petition. What happened is that the department went to the Court of Appeals and then in a split decision said that both of those statutory grounds, MCL 712A 2B1 and 2B2, that they both applied. There was an appeal to the Supreme Court, and then opinion was issued April 14th of 2025, and they concluded the trial court did not clearly err by refusing to take jurisdiction of DVL under MCL 712A.2B1 or 2 because respondent mother was not able to provide necessary care or support for DVL at home, and her treatment of DVL was not neglectful, and that would have been under 2B2. What they went to further define that when we look at the term in the statute of 2B1, when able to do so, able may be defined as having sufficient power, skill or resources to do something. And what they said is that respondent did not have sufficient power, skill, or resources. They also made a similar finding that there was no neglect by mom. And the Court of Appeals decision was reversed and the case was remanded back to the trial court for reinstatement. This was not a unanimous decision from the Supreme Court. There were other justices that concurred but said, Justice Kavanaugh said the available grounds for jurisdiction were ill-equipped to address situations involving children with serious mental health diagnosis, and he appealed to the legislature to fix this gap. There was also Justice Bernstein. He was concurring in part and dissenting in part. And this, I just want to make a record of this, but when he looked at
is that on January 9th, he assaulted Brandy Gillespie here in St. Joe County, someone you had a dating relationship with. We get literally dozens or hundreds of these in the course of a year. It's called domestic violence or domestic assault. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Anyway, this was an incident that happened at Laura Drive Apartment B in January with getting kids up for school and angry temperatures and tempers. Mr. Stickley, have you had a chance to discuss this with the defendant?
I have, Your Honor. At this time, he's going to ask the court to enter a plea of not guilty. It's not a matter of pre-trial. It would be appropriate to appoint an attorney.
All right. Who lived at the Laura Drive address?
Me and Randy both did.
Were you on the lease?
Yes.
All right, so you're out of there as a no contact provision?
Yep. But she filed, I have a court date here, May 6th. But she wanted to vacate the no contact order.
All right.
And I guess she has talked to the prosecutors. She didn't want charges pressed, but they took it up anyways.
Well, it's the people of the state of Michigan versus you, and so the prosecutor
has to.
And so we'll see. Anyway, I'll show you plead not guilty. Do out of apartment. Going to appoint an attorney. Set an attorney pre-trial for May 1. We are going to be very busy on May 1. All right, I'm going to send you out with the court officer. Did he get printed? And they're going to give you some paperwork with your lawyer's name and number on it. This is important. I want you to call the lawyer and discuss this with them.
Okay.
Prior to May 1st, and then you'll be here in the other building. By May 1st, we'll be on the other side in the big old historic courtroom. This charge has got different ways it could go. It could be a dismissal, could be a reduced charge, it could be a plea with a probation deferral, it could be a trial. But they'll get the police report, get victim input, be in a position to make some decisions about how to proceed on May 1st. So you make sure you contact your lawyer. I'll see you on the other side on
Thank
May
you, sir.
1st.
By the way, I watch you every day.
All right. Well, thank you. I'd say it helps people sleep at night because it's so boring. Audrey Clark. Good morning. I have some other visitors here today. Kelly was just here. I didn't know if you guys got arrested or something and needed to get arraigned. Some other friends are here to visit on our last day here. Good morning. You're Audrey Sue Clark?
Aubrey.
Aubrey. Yes, Aubrey. No, but they didn't write it wrong. I just read it wrong. You're charged with the infamous offense of no insurance. We get hundreds of these. It's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500. Carries no fine of not less than $200. So the minimum fine for this is $325. Rarely does anybody go to jail for this. There is we've got a couple of these today. There is a lesser offense known as no proof of insurance. And that's a civil infraction. It's not even a crime. Mr. Stickley says you have insurance now on the vehicle.
Yes.
Who's your insurance carrier?
Progressive.
You got a lot of Progressive. That's our goal, is to help people get insured. So what I'm going to ask you to do is have a seat for a minute. We're going to get a couple of these and we will enlist the help of the prosecutor. The prosecutor has the authority to reduce the charge. The judge doesn't. But almost always when the people come in and prove that they have insurance, the prosecutor is willing to reduce it, which will save you a whole bunch of money, and it won't be a misdemeanor, and it will be just a civil infraction. So you have a seat, and we'll come back to you in a bit. Is Ashley Armour here? Surprised she's not. I took every paper clip out of here. This thing is stripped down. I didn't even have any judgment forms here. Well, let's talk to somebody that is here. Stephanie Smith.
I'm ready. Oh.
What do you think I'm going to call your case now?
Possibly. I'm just prepared. I'm prepared for it if you call anybody.
Or calls the case of the people versus Javi and Lovelace.
Which is my case. Assistant Public Defendant Nick Buckovich on behalf of Mr. Lovelace.
Sir, can you state your name?
JV and Lovelace, Your Honor.
Thank you. All right, what are we doing?
I'll be asking for an adjournment. I'm working on the process of setting up an account to be able to may have visits with Mr. Lovelace. Although I do want to note, I did notice on the website for the Isabella County Jail, Mr. Lovelace may have a release date of the 18th of this month.
Oh, so Mr. Lovelace, are you getting out this month?
Yes, I am getting out. I've been incarcerated for 14 months now.
Got it.
So with that in mind, I believe he may have a low cash bond in this case since he's been in custody.
Yeah, he's got $1,000 personal cognizance. So
Okay, so it's perfect.
here's what I'm going to do. I'm going to adjourn the probable cause conference out. I'm going to give a date of May 7th, 2026, 9 a.m. All right. You got that, sir?
Yes, Your Honor. Do I just, when I get out of here, just show up to court?
That's it. That's what I'm trying to do so that you'll get out of there and then you got to come down here. So I'm trying to give enough time for that to happen. And then I'm going to reduce his bond. I'm going to make his bond $1,000 personal recognizance even at this time.
Perfect. I appreciate that, Your Honor.
And then that way this case won't hold you at all. And then you can, once you're out there, you can get out and then get down here. Okay?
All right, thank you, Your Honor.
All right. You better make sure you show up.
You said May 6th, which day?
What?
I'm gonna
What'd
be
you
there.
say?
What day
May
is
7th.
it again?
May 7th. See, you were gonna mess it up.
No. That's my mother's birthday.
This is
so
why
I'll be there.
This is why I don't do nice things. All right.
Mr. Lovelace, when you get
All right,
out,
thank
you
you,
get
Your
to
Honor.
a Washington County Public Defender's Office and make sure we have updated contact information for you, okay?
All right, thank you.
All right. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Michael Bedolla.
Kennedy for the people, Your Honor.
Good afternoon, Your Honor. Samuel Bennett appearing on behalf of Michael Bedolla, who appears via Zoom. We waiver in-person appearance and have no objection to Zoom today, Your Honor. Mr. Bedolla, can you state your name for the judge, please?
Michael Bedolla.
Thank you.
Thank you. What are we doing?
Your Honor, we are waiving the preliminary exam today, and Mr. Bedolla is ready for you to voir dire him on the waiver.
All right. Mr. Bedolla, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
Right. People also waive their right.
Yes, sir. Thank you.
Preliminary examination, heavyweight weight defendants bound over to circuit court on a single count.
Thank you, Your Honor.
Counsel, you waive formal reading, standing mute. You stand mute to the charges.
Yes, Your Honor. Thank you.
All right. Defendant have a waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for June 3rd, 2026, 1:30 before Judge Conlon.
Thank you very much, Your Honor.
Thank you. Bond
Have a great day.
continue. Thank you.
Thank you,
Your
Mr.
Honor.
Kennedy, as well. Bye-bye.
Take care.
They need to sign. Court calls case, People versus Christopher Johnson.
This is Melissa Press for the people, Your Honor.
Good afternoon, Your Honor. Ivan Land, P65879, appearing on behalf of Mr. Christopher Johnson, who stands to my right. Please state your full name for the judge.
Christopher Johnson.
Thank you. All right. What are we doing?
Your Honor, I believe the people were trying to figure out some things and we went discussing an adjournment of this PCC.
Yes. I joined your class. We still have a few things.
All right. Probable cause conference. Will April 30th work for you, Jones?
It will, Your Honor.
April 30th, 2026, 9 a.m.
All right. Thank you. Always a pleasure, Your Honor.
Bond continue. Thank you.
Your Honor, did you say 9 a.m.?
I said everything for 9 a.m.
Okay.
What will happen is you'll get a sheet that will explain which block you're in. It's
Gotcha.
through the afternoon.
I remember that. Thanks so much, Your Honor. Take care.
Court calls case, People versus Tejon West.
Good afternoon, Your Honor. Raymond Cook for the people.
And good afternoon, Robin McCoy, P63057, on behalf of Mr. Tejon West, who was approaching.
Tejon West. You want to spit out that gum?
I know you're telling you.
Sorry about that, Jan. All right. What are we doing?
It's set for PCC, but we've had discussions of, we want to adjourn this out to look into some other issues.
That objection, probable cause conference will be adjourned April 30th, 2026, 9 a.m. Bond will continue.
All right. Your Honor, thank you.
Court calls case, People versus Balin Johnson.
As adults, the people. I put them out with the minutes and
Mazi Carey, I can really, Your Honor, on behalf of, but not with Mr. Jalen Johnson, Judge. Your Honor, I am asking for an adjournment.
Like Bellinger.
I need to be more like Bellinger.
I'm just saying. Go ahead. I'm listening.
Your Honor, I have not been able to make contact with Mr. Johnson, but it's because he's deployed. We did have good contact information for him, but now it seems like that number is not in service. So I just
Wait.
yes.
That's my understanding as well, Your Honor. I reviewed the notes in the file. I think court previously gave him Zoom permission because he had been deployed to Germany. And the court had let him appear via Zoom. I have no objection to an adjournment to try to reattempt contact with him. And then hopefully we'll be able to resolve this case.
Sure.
All right.
Thank you.
Well, if he's deployed, I'm certainly not issuing a bench for it. So
Thank you.
I will adjourn probable cause. So May 7th.
Okay.
2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Maisha Jones.
Assistant Public Defender Deputy Lebo for Ms. Jones.
You know where she is?
I know where I expected her to be. If could we pass this matter?
You know what, Lebo? Is she here or no?
Not to my knowledge, Your Honor.
Okay. All right.
I would like the opportunity to give her a call if possible.
You want to give her a call? That's on the phone that rang the last time you were in here?
Different phone, Your Honor.
You know what, Lebo? I don't know why I'm doing this. Go call. Go call.
Thank you very much, Your Honor. I greatly appreciate it.
Never again. Not doing it again. Court calls the case People versus Cecil Levine.
Jake Henry for the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Levine, who appears via Zoom. Mr. Levine, can you please unmute and state your name for the record?
Cecil Levine.
And Your Honor, I am just asking for an adjournment at this time. I have asked for consideration on an offer. So just seeking a 2-week adjournment on this and also requesting to address bond for modification purposes.
I'll adjourn this to April 30th, 2026, 9 a.m. As to bond.
As to bond, Your Honor, I did send a couple pieces of information to the court last evening that you should have in your file. I've spoken with my client. He is homeless at this point, Your Honor, but he's still paying the mortgage at his house. He is trying to figure out a way to get the tether off his leg for purposes of being able to do one or the other. Money is tight for him. He's been on tether for a little while now with no violations. He's paying a lot of money, given that he is, again, paying his mortgage and for a hotel room at this time. He also, Your Honor, has informed me that he has a pancreatic mass. I have sent paperwork to the court. He was just informed that that's stage 2 pancreatic cancer. He is going to be having several medical appointments lined up here, including MRIs, for which hospitals generally will not give an MRI with a tether on his leg. Unfortunately, his mother recently passed in December 23rd of this same thing last year. So he is hopeful, given the amount of medical appointments that he's going to have as he starts chemo, that you'll grant him the ability to be off the GPS tether.
Respond.
Your Honor, I would object to the tether being removed in its entirety. That is a third matter with what I would consider concerning facts in which the defendant was intoxicated, yelling at the victim, saying, "I hate you, bitch. I want to kill you." grabbing the victim when the victim's daughter was present. I have, of course, no qualm with the tether being removed for the purposes of medical treatment. I know that your court is abundantly aware. I've had several cases before this court where Your Honor has signed many a stip for medical treatment. And certainly tether by no means be going into an MRI machine. I don't think it's possible. But I would have concern about the tether being removed in its entirety, but would more than happily stipulate to the tether removal for purposes of medical treatment.
He doesn't have that currently scheduled, does he?
Not that I am aware of, Your Honor. Those are appointments that he still needs to schedule at this time. He has obviously been to the hospital for the diagnoses, though, as you can see.
Right. I can see that. So here's what I'm going to do. At this point, I'm going to deny the request, but I would expect that counsel would work by way of stipulation once the appointments are known for the removal and then maybe the placement back, but within reason of got 2 appointments in a week. I don't want Monday to Thursday. I don't want him to have to remove it, then put it back on, then remove it again for Thursday. So just some reasonableness of how we do this. Okay.
Understood, Your Honor. Thank you very much.
All right. Thank you.
Thank you, Your Honor.
Yeah. Court calls the case People versus July Allen.
Good afternoon, Your Honor. Raymond Cook for the People.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Ms. Allen. Right.
Hello, your name?
Jayla Allen.
Last time too. Anyway, all right. I have before me a plea form. Is that what we're doing today?
Yes, it is, Your Honor.
All right. The plea form indicates that she's going to be pleading to 4 counts, as I see.
That's correct, Your Honor.
Count 2 of reckless use of a firearm, the 90-day. Count 3, operating while intoxicated, the 93-day offense. Count 4, carrying concealed while under the influence, the 93-day offense. And then the open intoxicants in a motor vehicle, the 90-day offense. Upon her successful plea to all of those counts, count 1 would be dismissed. There is sentence agreement of probation not less than 18 months in this case. That's the court's full understanding of the agreement, except that I'm assuming her plea is of guilty to these charges.
Yes, it is, Your Honor.
Your Honor must be understanding as well.
I'll just mark the guilty box. May I have her sworn?
You solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
State your first and last name for the record, please.
Jayla Allen.
Ma'am, it is this court's understanding that you are going to be pleading guilty to 4 misdemeanor offenses. Is that your understanding?
Yes.
All right. First of all, it's this court's understanding that you're going to be pleading guilty to count 2 of reckless use of a firearm. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court. Understand that? Then that also count 3, you'd be pleading to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The court could order community service and any rehabilitative services the court deems necessary.
Ms. Tranter, anything on behalf of the state?
No, sir.
Anything from probation?
Nothing further, Your Honor.
All right, Ms. Chambers?
Other than what we discussed in chambers, no, Your Honor.
All right, Mr. Wise, is there anything you'd like to say?
I've gotten really good help with this Genesis program. I've gotten to the point where they actually trust me enough to be a dorm rep in the dorm that I sleep in, to where I actually have responsibilities. They've made me what they call a big brother and a little brother, big brother program in that program. I've gotten pretty well up into phase 2 out of phase 3s, phase 1, 2, and 3. And I'm actually getting ready to phase up to phase 3 next week. And then after that, it's graduation and then sober living. So, and I've already got a deep hatred for the drugs at this point, but they are already taking my teeth now too. So, but Your Honor, I do seriously, sincerely apologize for any and all transgressions I've put against this court.
Mr. Wise, how long has it been since someone has trusted you to this extent?
It's been a while.
How's that feel?
Feels amazing.
All right. The court has considered the statements made here today, the pre-sentence investigation, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court will find that you are amenable to community control. So I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from use of any drugs, alcohol, or marijuana. Do you understand that?
Yes, sir.
All right. I want you to continue to successful completion of the substance use disorder treatment that you have started. One of the recommendations is the REACT program, and my only hesitation is he's doing so well right now. I don't know that I need to put another layer on him at this point. Your thoughts?
The only thing is he is somebody who would report in every week once he is at that position in his treatment to where he is eligible for that. The general casebook is a higher casebook, so the attention that he may need to in order to continue that motivation once he is back out in the community is my only concern on why I was.
Okay, so I guess my point is that as long as he's doing what he's doing in the Genesis program and then going into sober living, I don't want to put too much, back and forth on him with this duplicative or whatever.
Yeah.
That makes sense?
Yeah, absolutely.
All right, so maybe that's something we can hold back for now and see and just see how he does in transitions. He sounds like he's got a solid plan going from Genesis into sober living, and I don't want to disrupt that because he has done well since January.
Okay.
Right?
Yes, sir.
All right. Let's hold off on that for now then. So I'm going to not order the REACT program at this point. There is a component of this, the mental health issue. Are you getting any type of treatment or counseling?
Absolutely.
Okay.
Yes, sir.
All
I
right.
get therapy, psychiatric help, and medicinal help with the medications.
Okay. All right. I'm going to order you to continue, obviously, with that as well. Because you've been doing so well, I will order the monitor removed today. At some point in time, I do want you to get full-time verifiable employment, but again, that is something that is to me is secondary to your treatment. But that will be part of my orders that you need to get that and start working and paying your obligations. Now, you're also subject to discretionary period of post-release control, which means if you are sent to prison on this offense, the adult parole authority may choose to supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You also have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. The court does find it is indigent for the purpose of any fines, costs, or other financial sanctions. Last word, Mr. Wise, is it's always makes me a little bit nervous because the monitor is an added level of security, or you understand what I'm saying? Is it, now we start, okay, I don't want you to respond to that with, oh, I've got my freedom. And but
sir,
you understand. I mean, I'm very happy that you're doing well and that you're hopefully getting your life back.
Absolutely.
All right. Good luck to you, sir.
Yes, sir. Thank you.
This is case number 25CR43193, the state of Ohio versus Aaron Tussey. Mr. Tussey is before the court with his counsel, Mr. Brush, Ms. Nicholson, on behalf of the state of Ohio. We are here on the issue of competency. The court has received a report dated 4/7/26 by Dr. Autumn Richards. Has everyone had an opportunity to review that report?
Yes, Your Honor.
We have, Your Honor.
Do we have a stipulation to that report?
Yes, Your Honor.
We do, Your Honor.
All right, at this time, then the court will admit the exhibit, the report of Dr. Richards into evidence. Based upon Dr. Richards' findings, the court will find that the defendant is competent to stand trial. We're going to set this up for a further pretrial in 2-3 weeks and decide then which way we're going to go. Mr. Nicholson, anything else on behalf of the state? Mr. Brush?
No, Your Honor. Thank you.
All right, thank you all. That exhibit is directly behind you.